erstwhile consumer. I'm ready to pay. I'm already, the check is with me.
So pay and get connected.
Right. That is why a part harder already, an order has been passed by Justice Kaushik Chando. On that date, it was settled, my lord, before the court. It was informed that certain amount, 42,000 and odd amount, is unpaid. I'm ready to pay. Kindly
pay and
fix. No, my lord, an order has been not yet passed, my lord. Part hard.
You go and pay and then they will connect.
No, my lord, the order is required. Kindly fix the matter on 19th, my lord. I'll on that date, a short hearing will be happen, and the matter will be closed, my lord. And meter has been not yet connection in my name. And meter was the earlier consumer's name. I was ready to pay, but the meter should be in my name, no. That is why the matter should be disposed of. A short hearing is required.
18th.
Kindly fix in 19th, my lord.
Why 19th? Why not 18th?
18th, because check is to be ready. That is why. Kindly fix it 19th. I have
19th.
already communicate the matter to the other side.
Motion top. Unless other side is there, I will not take up.
I have already
Affidavit of service. Bring the affidavit of service.
I have already informed, my lord. Okay.
Bring the affidavit of service. And unless other side is there, I will not take up.
Because already I have communicated.
Mr. Counsel, unless your other side is there, I will not take up. Matter ends.
Kindly fix the 19th, my lord.
Last week, my lord, I mentioned.
Hey, last week, 19th motion top diye do.
Last week I mentioned one matter.
Take the microphone.
Last week I mentioned one matter. My lord was heard. My lord, the Honorable Division Bench remit the matter before the Honorable Single Bench. My lord, writ of 2021 to decide the issue of the, my lord, order, impugned order, which was not considered by the my lord, single judge. Order, my lord, order went up.
Hearing matter.
My lord, it's a
affidavit direction is there.
Already all are being completed.
Affidavit completed.
Yes, all are completed.
Mention and get it heard by the other benches. There are two other benches who are taking up, irrespective of
at present there is no benches, because at present no benches. My lord was pleased to fix it as to be mentioned. It is here, my lordship's noting also there. My lord was pleased to serve a notice upon the, my lord, government pleader, my lord Sishano Bandhavada, who appeared before the, my lord, appellate.
Sir, hearing matter, I will not be able to give you preference. Now choice is yours, because you have seen the list of hearing.
I know, my lord.
Too many matters.
But everything has been already been decided. My lord, petitioners are the, my lord, law officer of the district primary school council.
Right, all right.
Upgradation
hearing
of their scale.
Sir, you have to wait.
Because, my lord, direction there, that is why, my lord.
It will appear in the monthly list of November. But I don't know whether I will be able to reach.
Because, my lord, 2 months, my lord, request has been made for.
Sir, I will not, I cannot, sir. Then very well, one full day for your hearing matter. Before vacation, I don't mind.
Before that,
yes, tomorrow.
To be mentioned, my lord, let it be, my lord, heard first, my lord.
To be mentioned, where is the utility?
Because my lord desire was the matter be placed under the to be mentioned.
Very well, to be mentioned Monday.
Grateful, my lord. Extremely grateful.
Other bring the other side.
Yes, my lord.
Yes. This is a new motion matter, lordship.
Senior, yes.
Motion, my lord, for inclusion, my lord.
Service matter.
Yes, my lord.
What is the urgency?
The petitioner participated in the selection process of ICD supervisor, my lord, in service category candidate. Earlier bench, my lord, called for the report from the state respondent. State respondent filed this report, my lord. I have done particulars of exception, my lord.
Huh?
Exception file in the time of hearing, my lord. Kindly list of early date, my lord.
Motion service September 18.
My lord, one urgent matter of my
lord. What is the urgency?
Justice, my lord, Chandra, my lord.
What is urgency?
My lord, I am without electricity, my lord. I have filed it, the matter to be appeared on 30th July, but not appeared.
How much is the due?
No due, fresh connection in new flat.
Motion top Monday. Give notice, bring other side, otherwise I will not take up.
Yes, definitely. I will serve notice to learned adverse.
Affidavit of service and other side will come. Unless other side is there, I will not take up.
My lord.
New motion, may I be permitted to mention, my lord? New motion, my lord, it has not been taken up since January, my lord. I filed the same in January, but the same as not
Service,
service matter, my lord.
it's in the list.
No, my lord, not in the list. New motion. But the pension has been stopped to the petitioner.
August 26,
Deeply obliged.
Lordship,
motion service.
so this is a new motion matter. Item number 285 of monthly list in this month, Lordship. This is a new motion, fresh matter. Lordship, urgency is that, Lordship, due to some health condition, Lordship, I'm praying for, I want to resignation from my post, Lordship. I have applied more than 6 months. They have no reply. Then they serve me after filing of this writ petition. They serve me to transfer. But due to my health condition, I could not join the transfer post, Lordship. I want to resignation, Lordship.
You
I want to resign,
from the
Lordship.
service.
Lordship. The item number 285 is a fresh new matter, Lordship.
Tuesday, motion top.
Grateful.
Other side must be here.
Tuesday.
Your resignation letter is there,
No, Lordship, there is annexed with the writ petition, Lordship.
annexed to the writ
Lordship,
petition.
Lordship. Tuesday.
Service matter motion, earlier I have mentioned, your lordship asked me to come after few days later. But earlier lordship directed to be listed on June monthly list, but it was in the system showing it as in the list, but in the list it was.
দেখুন তো কি বলছে,
Lordship,
বলছে জুন মান্থলি লিস্টে ডিরেকশন ছিল কিন্তু জুনে নেই, কেন আসেনি?
system এর একটা দিয়েছি, ঘরতলা দেখুন।
কেন আসেনি? হ্যাঁ, so it is directed to appear in the monthly list of, কোনো ডিরেকশন আছে? হ্যাঁ, জুনে আসার ছিল, ফাইল আসেনি,
It was also not in the list.
তারপরে আর হয়নি। All right,
May I?
it will appear. It is motion service.
Service.
August 28, motion service, give notice, affidavit of service.
But may I seek your lordship please to mention a matter, my lord, but the disciplinary proceeding initiated on
Huh?
the disciplinary proceeding initiated on the basis of the memorandum of charge sheet, my lord, but my lord, my right to file representation, my lord, has been curtailed.
Why?
No chance has been given to file a representation against the memorandum of charge sheet.
Because show cause notice does not.
No
provide
show
for-
cause notice, my lord. RPF, my lord, the petitioner is the constable of RPF. My lord, it was initiated, my lord. So kindly, my lord, fix the date, my lord, so that, my lord, today is the tomorrow is the date for the proceeding. Tomorrow is the date for proceeding.
What is this? You have not yet filed.
My lord, not filed, it is affirmed, my lord.
To file, then get the number,
I'll-
then.
I will kindly fix a date, my lord, so that,
No,
my
I cannot fix a date. I will simply say upon urgency, leave granted to obtain regular number. Then you
Right.
get the regular number, then you mention.
oblige.
Upon urgency pleaded, leave granted to obtain regular number. Yes,
My lord, group 6 matter prints wages has been not paid and does not listed this matter.
huh? Yes,
No wages has been paid. And group 6 matter, my lord.
August 20. Motion service. Yes. Yes. To be mentioned.
সাপ্লিমেন্টারি এফিডেভিট একটা দিচ্ছি।
No, কি ব্যাপারটা আগে আমি বুঝি, টু বি মেনশনড আছে, কি হয়েছে? কি হয়েছে?
স্যার রেসপন্ডেন্ট নাম্বার 1 রচনা ভগত আর হচ্ছে উমা সেন অ্যাসিস্ট্যান্ট ডাইরেক্টর এর সাবজুডিস ম্যাটার নিয়ে আমাকে ইলিগাল মেমোস ইস্যু করছেন, এবং যেটা উনি করতে চাইছেন সেটা হচ্ছে একটা ইলিগাল ডিসিপ্লিনারি প্রসিডিংস যেটা এই কোর্টের কনসিডারেশনে আছে, সেটাকে কনক্লুড করার জন্য উনি 2/7/25 থেকে আমাকে কন্টিনিউয়াস উনি মেমো ইস্যু করে যাচ্ছেন, এবং মানে একই সময় আবার বলছেন মানে হাওড়ায় হবে ডিসিপ্লিনারি প্রসিডিংস জয়েন করো, আবার বলছে যে দার্জিলিং ট্রান্সফার করে দিয়েছি, ট্রান্সফার অর্ডার মানতে হবে, ট্রান্সফার অর্ডার ওইখানে দার্জিলিং এ চলে যাও। তো সেই কারণে আমি এই
আপনি দার্জিলিং যেতে রাজি তো?
স্যার দার্জিলিং এটা এই আমার বাড়ি হচ্ছে স্যার ভবানীপুর।
ওটা কোনো কাজের কথা না, চাকরি করতে এসছেন, সরকারি চাকরি, আপনাকে ট্রান্সফার হলে নিতে হবে।
সবার আমি ট্রান্সফার অর্ডার মানতে
বাস।
আছি, কিন্তু সেই অর্ডার ট্রান্সফার অর্ডার যদি পিউনিটিভ ভিন্ডিকটিভ হয় সেটা আমি চ্যালেঞ্জ করছি।
আপনি নিশ্চয়ই চ্যালেঞ্জ করেছেন, আমি চ্যালেঞ্জ শুনবো,
হ্যাঁ।
কিন্তু আমি ট্রান্সফার অর্ডার নর্মালি হাত দিই না।
ট্রান্সফারটা আপনি দেখবেন যদি আপনার মনে হয় তাহলে।
Lord, I am taking the point of maintainability, my lord. It should go to the, my lord, administrative tribunal.
Administrative
Yes.
স্যার অ্যাডমিনিস্ট্রেটিভ ট্রাইব্যুনাল নিয়ে অর্ডার
Lord, this is the fifth court. This is the fifth court. Lord, this matter is traveling.
All right.
স্যার 12/2/25 অর্ডার
এটা কি হিয়ারিং?
Four successive
এটা কি হিয়ারিং ম্যাটার?
released on personal ground. Released on personal ground, 4 different courts. Honorable court.
হ্যাঁ,
4 honorable coordinate benches will release this
না
matter.
সেটা কোনো কাজের কথা না, that
The
doesn't
fifth-
matter. But you tell me whether it is a hearing matter or a motion.
Motion stage.
Motion.
Lord, I have filed my report. Lord, I
I will hear you.
have
I will
taken the
hear
point
you.
of
You
maintainability.
argue the maintain.
ঠিক বলছেন না উনি, এটা হিয়ারিং
What kind of submission is this, my lord? My lord, all,
Affidavit
4
direction.
times it appeared, my lord, and my lord, all the matters, my lord,
একটা করতে গেলে এটা প্রসিডিউরাল ব্যাপার।
my lord, landed, my lord, coordinate benches release this matter. My lord, she has sought for release
স্যার সেটার কারণটা আমি তো দিয়েছি।
because all the courts opine that matter should go to the, my lord,
না
tribunal.
কোন এটা উনি ঠিক বলছেন না।
Very well. Why you are worried? I will hear. He has a right to take the point of maintainability. He will take. Then if I find, I will give my reason. Whatever order I will pass. Affidavit in opposition, reply সেগুলো কোথায়? এটা তো হিয়ারিং ম্যাটার, মোশন তো নয়।
Lord, we have filed our opposition, my lord. In terms of the order passed by Honorable Justice Mukherjee.
You have filed.
Yes.
ঠিক আছে, এটা ফরওয়ার্ড আসছে, আসুক, শুনানো। You argue the maintainability on that day first? আসুন। The writ petition appears today under the heading to be mentioned at the instance of MS Tanushree Roy, comma, the writ petitioner appears in person. Paragraph, Mr. Shantanu Kumar Mitro, learned advocate, appears for all,
State
all.
respondent, yes.
All the respondent, for the respondents. Paragraph. Though it is a hearing matter, since the petitioner appears in person
পেয়েছি কিনা দেখো বলো সে
and pleads an
check up করে
urgency,
না ফালতু বলবো তুমি মুখের কথা হবে না এটা আমাদেরকে দিয়েছে
the matter shall be taken up for consideration.
কি করবে তোমাকে অ্যাডভাইজার
You are there, you are for whom?
হি ইজ অ্যাসিস্টিং মি
আচ্ছা, কি বলুন? আপনি নিজে মামলা করবেন তো?
হ্যাঁ হ্যাঁ স্যার।
কোনো উকিল বাবু নেই
না
তো?
না
It shall be taken up for consideration under the heading for orders on August 19,
ইয়েস
2025.
মামলা আছে would you it
Well, kindly fix this, my lord. 22nd August, my lord, your lordship would be taking my lord contempt at us, 22nd August, Friday,
22nd,
August,
that's the contempt day.
yes. Then,
Come
my
on
lord,
19th, come on 19th, finish it off. Full stop. Mr. Mitra, learned counsel for the respondents, has raised the point of maintainability of this writ petition on the ground that the writ petition should be adjudicated upon by the jurisdictional state administrative tribunal. Full stop. The point of maintainability shall be heard first. Full stop.
and my lord, the supplementary affidavit just now, my lord, filed.
No, nothing has been
স্যার
filed.
আমি কি দিয়ে দেবো সাপ্লিমেন্টারি এফিডেভিট?
আপনি ওনাকে একটা কপি দিন, দিয়ে আপনি পরের দিন ফাইল করবেন। কপিটা ওনাকে দিয়ে দিন এখন। ইয়েস, আচ্ছা দিন, ফাইল করে দিন আপনি। On the prayer of the petitioner, leave is granted to the petitioner to file a supplementary affidavit. Full stop. Supplementary affidavit filed in court today is taken on record. Full stop. Copy has been served upon Mr. Mitra today in court. চল,
স্যার একটু সুপ্রিম কোর্টের অর্ডার কি দিয়ে দেবো?
কিছু দেবেন না, পরের দিন দেবেন। কোনটা? ডব্লিউপিও দিন, ওইখানে দেবেন, ওরা দিয়ে দিন, অরিজিনাল সাইডে দিয়ে দিন। আছে তো অরিজিনাল সাইডের লোক, দিয়ে দিন। কোর্ট অ্যাপ্লিকেশন হেডিং এ দিয়ে দিও। আসো না অজয়, আজকে আমার সঙ্গে না একবার দেখা করবেন আপনি, হ্যাঁ আজকে আমার সঙ্গে একবার দেখা করবেন, একটা নোট দিয়ে দেবো লিস্টে। চল।
My lord, in this matter, I am for the petitioner, my lord. This has come, my lord, at my instance, my lord.
হ্যাঁ,
My lord, I am for the petitioner, my lord. This has come at my instance, my lord. Well, as directed by lordship, I have served notice upon the other side, my lord.
why it is to be mentioned?
My lord, to be mentioned is this, my lord, the affidavit directions, my lord, kindly will look at the past order passed by your lordship, my lord. The affidavit directions, my lord, the date have expired, my lord. Not only affidavit number, but even reply date also expired. So, my lord, since no affidavit, kindly, my lord, and urgency is, my lord, in the last page, my lord, and I have not been paid salaries, my lord, for the last 2 years salaries. Kindly have a look
Yes,
at.
who is there?
Yes, lordship.
My lord, we are
Meet please, your lordship. Lordship, I am for respondent number 1. Lordship, on the last occasion, lordship direction was to file the affidavit. But what happened, lordship, in the meanwhile, the authorized person who was looking after these cases, he is dead due to an accident in Durgapur highway. So the further they have authorized a new person and he is unable to procure all the documents at the same time. So lordship, we are paying for 2 weeks extension time to file
Very
our
good.
affidavit.
And my lord, 1 week thereafter, I will,
Lord, we are for the respondent number 2, 3, and 4.
and my lord, one humble prayer, my lord.
মারা গেছে। না না, যে আগে যে অথরাইজ ছিল না, যে এই ম্যাটারে যে দেখতে তো পরিবেশন করলে প্রত্যেকটা ইসে আলাদা আলাদা হয়।
Mr. Counsel,
My lord,
the matter has been directed to appear under the heading September monthly list hearing.
yes, yes, my lord.
Why did you mention?
Mention, my lord, kindly have a look at it. The affidavit of direction was, they expired already 15.
So what?
My lord, 15 July, it has expired, my lord.
So
Then, my lord, no, my lord, since the no affidavit has been filed, my lord,
So what?
so my lord, only thing is this, my lord, only thing is this.
So this is the way you will get a preference.
No, my lord, the urgency, kindly have a look at the urgency, my lord. Since, my lord, no affidavit has been filed, and affidavit reply date also is going to expire tomorrow. So, my lord, what is the use of keeping it, my lord? Kindly have a look at the urgency.
Mr. Horishankar Chattopadhyay, learned counsel, appears for the petitioner.
My lord, with me, my lord, I'm Chittaranjan Panda, he is my junior.
Mr.
Chittaranjan Panda.
ইন্দ্রদীপ দাস।
Indrajit
ইন্দ্রদীপ দাস,
Indrodeep Das, learned advocate, appears for
রেসপন্ডেন্ট নাম্বার 1.
Respondent number 1, Mr.
Brijendra Pratap Singh.
Brijendra Pratap Singh, Learned Counsel.
For respondent number 2, 3, and 4.
It appears for respondent number 2 to 4, 2 to
And
4.
my junior is Amal Kumar Datto.
Give name, give
I
name
have already.
in writing, give name in writing.
ওটা তো ওখানে দেবে তো লিখে দিতে হবে তো।
Though the matter has been directed by an order dated June 23, 2025 to appear under the heading hearing within bracket service in the monthly list of September 2025. But since the affidavit in opposition has not been filed on or before July 15, 2025, comma, the matter has been mentioned
লিখে দিবি।
and appears today under the heading to be mentioned at the instance of the petitioner.
And my lord, reply date also is going to expire tomorrow, my lord. Kindly have a look at the order, my lord.
Such practice is not appreciated
ERI
by this court.
JEN JEN DRA DRA Pratap PRATA
Paragraph. However,
single INGS.
since an extension has been paid for filing affidavit in opposition by the respondents,
এখানে সিনিয়র কাউন্সিল করে দিই।
comma, on the prayer of the respondents, time to file affidavits in opposition stands extended till date.
Within this month,
No,
31st August.
28
August,
27.
28 August,
August
August 28. 28 August, my lord.
28,
August.
2025. Affidavit in reply,
Within 7 days, 7 दिन बोलो।
Yes, yes.
कौन तारीख
7 days, my lord.
तारीख का दो तारीख 7 days 28 तारीख my lord
5th September goes.
give me the date.
5th September my lord
Sorry, no.
my lord 7 days
Sorry, no. He is filing August 28.
I am ready to file within 7 days.
Thereafter, my lord.
That's right. Matter will appear in the November.
No, my lord, only thing is this, my lord.
Sorry, no, this practice is not appreciated.
My lord, why the practice?
Very well.
My lord, kindly
You do whatever you want, sir.
No, my lord, I am before you, Lord. My lord, kindly say.
Sorry.
But
You file, tell me when you will file.
I will file by 5th September.
Very well. Do one thing. Ajay kaun tare?
13 August.
You file by 25th August.
Right, my lord.
August, affidavit in opposition by August 25, 2025.
Okay.
Affidavit in reply, if any thereto, shall be filed by August 28,
Yes, my lord.
2025, 28. The writ petition shall appear under the heading hearing within bracket service in the monthly list of September 2025
My lord, kindly make it daily list, my lord. Kindly make it. My lord.
as already directed in the previous order dated June 23, 2025.
I'm getting.
And my lord, one thing, my lord, I beseech your lordship, my lord, this has been, it has fallen
Next.
from, my lord, kindly bear with me. It has fallen from, my lordship, this practice is not appreciated. Kindly consider our predicament from the.
Next,
My lord, kindly pray, my lord,
Next.
when the affidavit of opposition is not filed, my lord,
next.
my lord, this practice is, your lordship, my lord,
Next.
No, I don't, my lord, I beg to differ with your lordship.
Next.
This practice is not at all.
Sir, you are free to challenge this order.
My lord, I am before your lordship, I am protected.
You are free to challenge
No,
the
my lord,
observation of
My
this.
lord,
court.
I feel safe and secure. before
Sir,
lordship.
you have a statutory
No, my-
right.
No, my lord, I
You
think, my lord,
exercise that.
now your lordship has to reconsider the practice. This,
Sorry, no.
what has fallen from your lordship, this deprecated, at all not
It
deprecated.
is a sharp practice.
Well, I beg to differ with your lordship.
That's why I say, sir.
Hello.
go and take a
My lord, I feel
test
seven,
it.
kindly make it part hard. I will feel 7-6, my lord.
Next,
Not that, I want to avoid this court, my lord. I am very much here, my lord. I feel protected by your lord.
next.
Actually, I have for the petitioner in this
The
matter.
statement.
It has come at my instance, Lordship, upon
I am
petition.
appearing on behalf of Union of
The
India.
matter, my lord, petitioner has entered an agreement, executed lease agreement with the railways in the year 2020.
Identical matters.
Two identical matters.
Yesterday the order
No,
passed.
no, no, that was a different matter, my lord. This is a
Okay.
different matter. Here I'm asking for rearrangement of my consignment, which was
All right.
alleged to be overloaded by the railways. Now, my lord, petitioner executed but lease agreement with the railways in the year 2021.
Wait. Yesterday's order you have got on the server?
Grateful.
Yes.
My lord, petitioner has
You are for the railway?
It's for the legal matter.
I am appearing on behalf of Union of India.
For the statement.
You are for railway?
I am for the statement.
My lord,
Yes.
petitioner has executed one
Take the microphone.
petitioner has executed one lease agreement with the railways. My lord, this is pertaining to a wagon. Lordship is aware that wagons which are gets attached with the Mail Express train. Here it's Kanchenjunga Express, my lord, where the tender has been floated by the Eastern Railway. And I took part in the bidding process, and my bid was considered as the highest. And accordingly, my lord, agreement was executed with the senior divisional commercial.
Tell me about the scope of the agreement.
Scope of the agreement is, my lord, I have to load consignments there.
You are a transporter.
Yeah, I'm a transporter. I'm a load consignments, and the maximum carrying capacity of the wagon, my lord, as delineated.
Rake.
No, it's not a rake, my lord, it's a wagon.
It's a wagon.
Rake consists of several wagons.
Several, right.
So wagon, my lord, is delineated in the agreement is 23 tons. So what I have to load is within the 23 tons. It should not
Go beyond 20.
beyond. If it goes beyond, my lord, railways have the mechanism to detect the same through detect the same
Correct.
through in-motion weigh bridges, because it passes through the in-motion weigh bridges to check and verify whether it is overloaded or not. If it is overloaded, then excess load has to be shaved off from the wagon, and the rest will be taken forward to the destination station. Here, my lord, the originating station, as per the agreement is concerned, is at Shialda, and destination station is at Agartala, that is coming under Tripura, my lord. Now, my lord, on one day, my lord, on 23rd of July, I have loaded certain consignments at Agartala. Upon paying the freight charges to the railways, railway had made available.
You have loaded at Agartala.
At Agartala.
So it will reach at Shialda.
It will reach at Shialda. Now, my lord, upon reaching Shialda, I have declared that I have loaded 22.500 kgs, that is 22.5 tons in 23 22.5 tons.
So 0.5 tons less.
I have left open. Lesser. Now, my lord, when the said consignment along with the wagon was weighed in Shialda, it was found that there is an allegation of overloading against me, that I have overloaded by 6.63 tons extra. Accordingly,
so after it has reached its destination at Shialda, when the consignment was supposed to be unloaded, it was weighed and it was found to be in excess.
Now, accordingly, my lord, they have issued one. Accordingly, my lord, they have issued one impugned payment report, and on the basis of such impugned payment report, my lord, they have calculated the punitive penalty, and my lord, they have served upon us and asked us to pay the amount as a precondition for release of the materials and the consignments. Now, my lord, I have immediately made a representation before them that, look, I have declared in my manifest that I have loaded within the permissible carrying capacity. So if you allege overloading against me, in that case, I have a right
under Section 79 of the Indian Railway Act, seeking reversal of the consignment once again at my own charges. And that particular right is there as per in the Indian Railway Act. And subsequently, my lord, there was a division bench judgment on this, and the matter was referred to the full bench, and full bench has answered the same on affirmation. And thereafter, all coordinate bench judgments have upholded the right of the consignor and the consignee to exercise the right of 79 to cross-verify the allegation of the railways. Now, my lord, in these two writ applications, I made representations before the authority. Now, the authority did not take any actions on that, which compelled me to file a writ application before this honorable court, my lord, seeking reversal of the consignment at my own cost. Now, my lord, if your lordship kindly see the judgments of the honorable division bench.
No, not required at this stage. I accept.
No.
Section 79 provision, I accept.
Yes. My lord.
So at this stage, what you can do, you can deposit the entire amount. Whatever they have claimed.
Yes.
Get released your material.
Upon exercise, please.
Let me complete. I may be technically wrong because this. No. I tell you why. It might happen because there's so many technicalities are involved. Might happen. Broadly, the proposition of law, I can say, you pay the entire amount, whatever they have claimed, without prejudice to your rights and contention. It will be kept by them in a fixed deposit amount. Right? You get your material released, consignment released, do it, you do your business. Right? They shall consider your representation for revayment, and then to fix their claim, and you will have a right to contest their claim.
My lord, to this, my lord, my
representation has already been considered by the authority.
No.
This is your lordship kindly see.
Have you got it?
My lord, may I say to this, my lord? My right.
Have you disclosed it?
No, I have not received anything.
Oh, you have not received.
I have not received. When the matter came up for consideration.
Look at it. It's in your favor. Look at it. At a copy now.
Because
I
when
don't
the
have it.
matter came up for consideration before Honorable Justice Chando on the previous occasion, we urged the same thing. It was not produced before the court on that relevant point of time.
That I know.
That point was not raised.
No, what?
There is a circular, my lord. Your lordship kindly see. I'm very sorry, my lord.
Yes.
It is marked.
So you do one thing. You pay the entire amount without prejudice, get your consignment released. They shall, then you contest your claim. Then you contest your claim.
My lord, may I say to this? The statute clearly says, in no uncertain term, my lord, that my right of reversal shall only remain before I take delivery of the consignment.
Now you have to challenge this impugned order.
My lord, may I say this? Even if they have regretted it because they have not served it upon us, how they have served upon us?
Served.
My lord,
Look at it.
may I say to this? Full bench has recognized my right.
Yes, I also say you have a right.
I say this. I put in all the charges. Now, let them carry out the reversal as per the statute and as per the judgments of the honorable court, which I have annexed here.
No, that I cannot.
Or else, my lord, my right.
They have done it.
No,
They have. Yes, they have done it. Regretted means they have done it, and they refuse to accept your contention.
No, my lord. May I say?
Revayment has not been done.
No.
Why?
Once, my lord, it is once reweighed, my lord, weighed, my lord, and there, your lordship kindly see the circular, your lordship, that yellow color, my lord.
Yes.
It is marked, my lord, where it is specifically stated, my lord, that.
Give him a circular. If it is circular.
I have the circular.
I don't have that
circular
extra copy, my lord, your lordship kindly.
Contention that payment has to be at my presence. It is clearly stated in the said circular. And it cannot
Have you followed this circular?
Lordship.
Was it in his presence?
Yes.
Yes.
so far, my lord, my instruction. Yes, my lord. In his presence, my lord, it was taken.
So very well.
My lord, may I say this? May I say this? When the consignments arrived at Shialda, they have checked it and they have said that I have overlooked it. I made a representation and I have asked for exercise of deliverment upon payment of all charges. Rashid, I will take delivery. But if my deliverment, my right of deliverment goes, if I take delivery, my lord, in that case, I put in all the charges. That is what the coordinate bench has said.
Very well. You do one thing.
Lordship.
At present, he shall pay the entire payment.
Lordship.
Right? Upon entire payment being made, you reweigh the thing in his presence. Right? Then you allow him to take the consignment, and if you find that your contention is correct, it was overweight,
Lordship.
then his money, he will already deposit the entire amount.
Along with damage charges, my lord.
Whatever.
Lordship.
Whatever. You will forfeit it, you will take it in your favor.
Lordship.
If it is found that the weight is lesser than the 23
tons,
then the amount will be proportionately refunded to him.
That is the judgments of the Honorable High Court.
That has to be, sir. It is the commercial law
Yes.
at the end of the day.
Lordship.
So
That
do
is-
that. It's a commercial law at the end of the day.
And all the judgments, my lord, all the
Initially,
orders, my lord,
my lord,
says
initially the
same thing.
petitioner have to deposit the entire amount.
I will.
He's saying
Along with all charges and
so.
damage charges.
He's saying that.
Lordship.
My lord, only one thing, my lord. As I have disputed the readings of the in-motion way bridge, and in-motion way bridge is malfunctioning.
No, it is.
Just a minute. It's a proposal. If the repayment can be done in weighing scale, that will be at least
The court is not the expert. Sorry.
alternatively.
It is period.
No, in terms of the circular.
It is periodically.
Sir, in terms of the circular,
Lordship.
Yes.
huh? The mechanism is mentioned in the circular.
Lordship.
Show me from your writ petition where the circular is. You have annexed.
Circular. My lord, circular.
Show me. You show me where is the guideline for reweighment and all.
27.8, page 74. Page 74, my lord, 27.8. Effort should be made to conduct weighment in presence of the concerned leaseholder or his representative. And right to reweighment is as per section 79.
Show me.
Your-
Following what?
Your lordship kindly see 27.9.
Achha. Show me following which procedure you will carry out the weighment. Matter ends. There must be some procedure laid down that you have to follow these, the procedures.
My lord, as per the circular, my lord, which I have given to a lordship, my lord, on the basis of
3rd May 2021.
Yes, lordship.
Matter ends. 3rd May 2021.
79 also says the same thing.
3rd May, you know 3rd May.
2021 I have annexed. 3rd May but the 79 also says that I have to deposit all the charges.
Sir, I am not on deposit. You have accepted that. There should be some rule. আপনাদের কি নিয়ম কি আছে রিপেমেন্টের কি ফলো করবে
পেমেন্ট ডান তারপর রিপেমেন্টের কোনো ইয়ে নেই
না আপনারা তো উনি তো ছিলেন না রিপেমেন্টের
পার্টি ছিলেন কিন্তু রিফিউজ করেছেন
সো যাই হোক সেটা ডিসপিউটেড কোয়েশ্চেন দরকার নেই আপনি আরেকবার করুন ওনার প্রেজেন্সে সেটার কি ফলো করে করবেন কোন রুলস আছে তো যেটা
রুলস এরকম কিছু রিপেমেন্টের ওরকম কোনো তো রুলস নেই স্যার তার জন্য তো আমরা এর জন্যই তো আমরা এটাকে করেছিলাম স্যার
Would you kindly direct them to conduct repayment as per section 79 upon deposition of all charges?
Section 79 to देखिए. हाँ, आशु.
I will deposit by today.
It is up to you. The day you, after you deposit, they will do that. The writ petitioner carries on business. Now, Tarage, what is your name, sir? Mr. Saptorshi Roy, learned advocate, appears for the writ petitioner. Mr.
Dijodas Chakraborty. Dijodas Chakraborty.
Dijodas Chakraborty, learned advocate, appears for the railways. Mr.
Shivashish Banerjee
Shivashish Banerjee, learned counsel, appears
for
for
the state.
the state. Learned advocate.
Lord, I'm
appears
led
for
by the learned GP. I'm led by the learned GP.
Where is he?
But he is engaged in another court matter.
কি বললাম? না, কি নাম বললো?
আরেকবার নামটা বলো তো।
Shivashish Banerjee.
Mr. Shivashish Banerjee, learned state advocate, led by Mr.
Amitabh Broto Roy.
Amitabh Broto Roy, learned additional government pleader.
GP man.
Learned government pleader, appears for the state. The writ petitioner carries out business as a carrier poster. Pursuant to an e-auction held by the railways. Just now both of you listen so that facts are. Pursuant to an e-auction held by the railways, comma, the petitioner as the successful tenderer has sent its consignment to a leased out wagon from Tripura to Shialda. The ceiling limit of capacity of the wagon is 23 tons. The petitioner contends it had sent consignment for about 22.5 tons.
Submitted one manifest.
Huh?
Submitted one manifest before the authority where he has specifically stated that he will carry 22.5 tons.
The petitioner contends that it has submitted one manifest before the concerned authority for sending the consignment, for transmitting consignment for a total capacity of 22.5 tons. Which is less than 23 tons. When the consignment reached at its destination at Shialda station, upon weighing the same, the railway found it to be more than 23 tons. What was the quantum exactly you found?
6.630.
6.630.
Excess.
6.3 tons excess.
Found, কি বললাম? Found to be more than 23 tons by 6.63 tons in excess. Accordingly, the railways has charged the Penal charges. Mr. Railway Council, please inform. Please tell. Penal charges along with
Only penal charges. Penal charges along with, my lord, that was for penal charges, and at present moment it will be, my lord, also demerit charges to be
so
included.
penal charges for a sum of rupees
3,24,982.
Yes.
penal charges for a sum of rupees
3,32,000, my lord.
3,32,000. 32,000. As would be evident from page. Page.
My lord,
Where you have annexed.
they have not said so, but unofficially it's 3,32,000 as per the railways.
How can I record something which is unofficial?
My lord, record the punitive charges.
Very well. Let us not mention the quantum. কি বললাম? For something কেটে দিন।
My lord, page 7 it is mentioned, my lord. Page 7 of the writ petition.
3,24,982.
That is demand for overloading charge. Overloading.
This is
And
So that's the amount.
and demerit charge will be added.
Absolutely. Please first one by one. Page 7.
Page 7 of the writ petition.
Which paragraph?
Point 12, my lord.
12.
Para 12.
Para 12.
Middle portion.
Okay.
3 lakh.
কি বললাম? আবার পড়ুন। Full stop it for accordingly. Railway. And demanded a sum of rupees 3,24,982 for overloading by 6.630 tons as pleaded in paragraph 12 of the writ petition. Paragraph. Where is the representation?
Representation, my lord, I have annexed.
Page
41. Page 43, my lord. Page 43.
paragraph. By representation dated July 26, 2025, Annexure P5 at page 43 to the writ petition, the petitioner requested the railways for reweighment of the consignment. The petitioner contends that no such reweighment was done. Paragraph. Give me that paper. Reweighment done.
Well, reweighment was never done.
Reweighment was
Sir,
never-
they are submitting it is done. Should I not record that?
Weighment done. And it, this is the reply of their, my lord, representation.
Okay. Okay. কি বললাম? No such reweighment was done. Paragraph. Mr. Dijodash Chakraborty, Learned Counsel, appearing for the railways, comma, at the outset, has placed a communication dated July 28, 2025. Addressed to the petitioner by the railways, wherefrom it appears that the said representation oblique appeal of the petitioner has been considered and the request of the petitioner was regretted. Full stop. The petitioner was requested to unload the consignment from the subject VPs at the earliest by paying all applicable commercial dues. A copy of the said communication dated July 28, 2025 is taken on record. Full stop. Paragraph. Learned Counsel, Mr. Saptarshi Roy, appearing for the petitioner, has denied this contention of the railways and submits that the said communication dated July 28, 2025 was never served upon the petitioner. Post. Paragraph. In the light of the above, the petitioner prays for reweighment of the consignment in terms of the provisions laid down under section 79. Acha, reweighment na, weighment kore dao. Weighment of the consignment in terms of section 79, a section theke bold hobe, 79 bold, of the Railways Act, RCAP, ACAP, comma, 1989. Post. The petitioner submits that it is agreeable to deposit the demanded sum as mentioned above, along with all
other charges.
applicable commercial charges. And upon such deposit, the consignment may be released. And upon such deposit, the consignment may be weighed following the procedure under section 79 of the Railways Act, and then the same may be released forthwith in favor of the petitioner. And thereafter, the claims and cross claims of the parties can be decided between themselves in accordance with law. Full stop. কি বললাম এই জায়গাটা আবার পড়ুন। All applicable commercial charges in accordance with law. In accordance with law. Proper. Upon such deposit being made, the consignment, upon such deposit being made, the consignment may be weighed following then the same may be released. Full stop. Full stop. Petitioner full stop. Thereafter, take a notun sentence. Thereafter, the claims and cross claims of the parties can be decided between themselves, following in accordance with law. Full stop. In view of the after considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that Section 79 of the Railways Act provides for a right in favor of the consignor for weighment of consignment on its request. Consignor na, consignee. on the request of the consignee. Poster. The records available before this court and from the submissions made on behalf of the parties, it appears to this court that in terms of the appeal of the petitioner dated July 26, 2025, the Railway Authority had merely communicated its regret thereto for not considering this. Nothing on record shows, neither from the submissions of the parties it appears, that the provisions under Section 79 of the Railways Act has been complied with. In view of the above, the petitioner shall forthwith deposit the said sum of rupees 3,24,982 as demanded by the railways, along with all applicable commercial dues in accordance with law in connection with the subject consignment before the Railway Authority. Poster. Paragraph. In the event the entire sum is deposited by the petitioner, comma, as directed above, comma, the railway authorities shall cause the payment of the subject consignment in strict compliance of the provisions laid down under Section 79 of the Railways Act, positively within a 48 working hours from the date of deposit. From the date of deposit to be made by the petitioner.
Instead of 48 hours, your lordship can
72 hours. Done. 72 working hours from the date of deposit to be made by the petitioner. Paragraph. After the payment is over, in terms of Section 79 of the Railways Act, comma, the railway shall release the consignment in favor of the petitioner without any further embargo, and the petitioner shall lift the consignment out of the custody of the railways positively within 24 hours immediately from the release of the consignment. এইসব টাইমগুলো কিন্তু বোল্ড হবে, ঠিক আছে? বুঝতে পেরেছেন? The parties, both the petitioner and the railways, paragraph, thereafter shall be at liberty to proceed to exert their respective claims and cross claims against each other in accordance with law. Full stop. Paragraph. In view of the above, nothing further survives in this writ petition. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition WPA 17679 of 2025 stands disposed of, without any order as to costs. Thank you. Thank you.
Well, next matter is also same. Only the difference is only the difference is overloading allegation. Allegation overloading is of 1,900.
এটা দিয়ে দাও, এটা থাকবে। আচ্ছা, পরের কাগজটা দেখি। লিখুন overloading.
Page 20, page 7.
No, first you tell me the paragraph where he has said.
Page 7, para 12.
আরে এই কাগজটা কেন? পরেরটা।
Page
ও
7.
আচ্ছা, 1 second. একদম মাথার উপর ফার্স্ট প্যারাগ্রাফ শুরু হবে। Upon urgency being pleaded and upon the matter being mentioned, and since the regular determination has been assigned before this court, this writ petition has been taken up for consideration by publishing the same in the daily cause list. বলুন।
Page 7, paragraph 12.
Para 12.
আপনি লিখতে থাকুন দিদি, ওগুলো ওখানে ফিট ইন করে দেবেন। পেজ 7,
paragraph 12.
অ্যামাউন্টটা লিখুন 52,000, 52,000,
And overloading.
overloading by
1950
kgs.
This is the only difference.
1,950 kgs.
Well, there is a tolerable limit of 1 ton. If it is excess of 1 ton, there is no
Alright.
punitive charges.
52,000 হলো 1950 kgs, এটা হচ্ছে এক্সেসটা হলো, টানের জায়গায় কেজি হয়ে যাবে। আর প্যারাগ্রাফ হচ্ছে 12 হলো। আর কি বলেছি? অ্যামাউন্টটা, ও অ্যামাউন্ট তো বলে দিলাম।
Well, date of representation is page 41.
Date of representation, page
41.
Date of
28
এক মিনিট wait.
41.
Date of representation, July 28, 2028. Page 41. And you give me your that official memo. It was regretted.
Right.
এমন লিখেছে বুঝতে পারছি না। 28 July 2025, annexure P5 at page 41.
There is only one copy.
It was not
That is doesn't matter. Give it to me.
No, in this matter there is no copy.
No such. তাহলে তো ওটা আবার চেঞ্জ করতে হবে ওখানে।
Both the writ petitions cover in one.
Both the representations are covered by that particular. Okay. Same, it will be same.
ওই শুধু আমি করে দেবো, লিখে রাখুন, ওই টেকেন অন রেকর্ডটা এখানে হবে না, টেকেন অন রেকর্ডটা বাদ।
My lord, liberty to communicate the order, my lord, let them act on basis of this order.
Let them not act and you come back.
Grateful. Good.
Yes,
So I'm applying
application for
application for restoration application.
within time,
Lordship, 190 days delay, Lordship.
190 days. Where is your other side?
Lordship, I have served to the WP, West Bengal.
Passed over for the day, serve and come back.
Lordship, I have served, but the difficulty
Once again, you have to serve, sir. There is a delay.
is a bit of service. Lordship,
I don't disbelieve, but there is a delay.
Lordship, there is a difficulty is the state has not received the copy as because the matter is listing matter is running in the list. That's why the state did not receive the copy because there is a 48 hours of time for serving the matter. So my lord, kindly keep it next week. Then I will serve and come.
You serve and come back.
Lordship, then keep it Monday. Then I serve and come.
This is an application for restoration, full stop. There is a delay for about
190 days.
190 days. Paragraph. Mr.
Sheikh Aftabuddin. Lordship.
Appears for petitioner. Paragraph none appears for the respondents. The petitioner shall once again serve a notice at the office of the learned government pleader and file an affidavit of service when on the next day. In the event, paragraph, none appears for the respondents on the next day, the application may be taken up for consideration for final order. Application may be taken up for final consideration. The matter shall appear under the heading application on August 28, 2025.
I beg to pay for the petitioner, my lord. My lord, the petitioner were to file their reply, my lord.
Respondent, my lord.
But although the affidavit is ready, my lord, it's yet not affirmed, my lord. I'm paying for a week's
My lord, I'm
extension.
filing my affidavit in opposition on behalf of Union of India, my lord.
Opposition or report?
Opposition, my lord.
Opposition, my lord.
But
Opposition,
how
my
will
lord.
it be taken up as motion?
My lord, it was under the heading for orders, my lord.
Oh.
Paying for a week's extension, my lord. Can be taken up any day, my lord, after that.
On the prayer of Mr.
Devopriyo Samanto. Devopriyo Samanto. I'm led by Mr. Bojes Jha.
Devopriyo Samanto, learned advocate, led by Mr. Bojes Jha, learned advocate, appearing for
Union of India.
Union of
PSF
India.
Union of India.
Time to file affidavit in opposition stands extended till today. Full stop. The affidavit in opposition filed in court today is taken on record. On the prayer of Mr.
Qazi Ardan Ali.
লিখে দিন কি নাম বুঝতে পারলাম না। For petitioner, time to file reply stands extended
Only a week, my lord.
till আজকে কত? August 29, 2025. The writ petition shall appear. আচ্ছা, Mr.
Himadri Shikhar Chakraborty along with Sushnita Saha for the state given.
Himadri Shekhar Chakraborty, learned advocate, such and such, with such and such appears for state. The matter shall appear under the heading for orders on September 18, 2025.
Deeply, lordship.
My lord, may I pray for a short indulgence, my lord? My lord, can it be taken up at 2 p.m., my lord? 2 p.m.
Yes. Ashun.
2 p.m.
2 p.m. on 8th October.
Deeply obliged.
Hold on.
8th October.
8th October is probably
লিখবেন না না এসব লিখবেন না ওটা অষ্টমীর দিন
no. Or it's to appear on 18th of September. My lord. Deeply obliged.
My lord, in item number 7 also, my lord, I am appearing for the petitioner. The affidavit in reply is not yet ready. My lord, time may be extended by 3 weeks.
The last occasion also, I am for the.
On the prayer of Mr.
Sanjeev Kumar Mukhopadhyay.
Sanjeev Kumar Mukhopadhyay, learned advocate, appearing for the petitioner. Time to file reply stands extended till. Oh, you come after vacation.
That will be better.
Till the September 15, 2025. The writ petition shall appear under the heading for orders. On
1 week
November
after
18.
vacation. 1 week after vacation.
November 18, 2025. Mr.
Sen.
Sen, Learned Counsel, appears for Union of India. Give your name.
আমরা যেটা ফাইল করে রেকর্ড করেছো তো?
Baba. I'm grateful, my lord. I'm grateful.
For the petitioner, my lord.
ওটা কিন্তু এই 8th of October লিখবেন না। 8th of October 2 p.m. লিখবেন না। ওটা অষ্টমীর দিন।
But this matter, my lord, relates to compassionate appointment in the Food Corporation of India. My lord, my the petitioner's father, my lord, expired in accident when in 2019, 13th of June 2019, the accident occurred. As on the same date, my lord, he expired. It's a case of, my lord, death at workplace. My lord, application was made. Thereafter, it was kept pending. My lord, the stand taken, there was a report filed.
Date of death?
My lord, 13th June 2019.
13th
June.
Petitioner is the daughter.
Is the son.
Son claims.
My lord.
Page, death certificate.
Page 16.
Application dated
31st July 2019.
Within the prescribed format.
The application was made in a later, my lord.
That was not the
that is not the issue, my lord.
issue. Is this, my lord? There is
Page application.
Application is page 17.
Yes.
Thereafter, my lord, certain documents were sought for. Those things are taken care of. The issue now.
They rejected.
Yes, no, it was kept pending when I approached this honorable court. In this court, lordship directed them to file a report. In the report, they say that in.
Show me the report. Yes.
Well, first, they have taken the point is that this is not a vested right. Those are the common points, my lord. The main issue is that, my lord, the departmental worker has been declared as a dying cadre. My lord, that is at page. Departmental workers. My lord, in FCI, there are several types of workers. This person who died, my lord, was a departmental.
The department is dying.
Not the department. The departmental.
Declared as dying cadre.
Dying cadre.
Inclusion in that cadre.
This has, but my lord, my point is that, my lord, this notification which says that departmental work.
Show me your policy for compassionate appointment.
My lord, you'll also kindly see a report. Is a first, you'll also kindly see.
Show me the policy for appointment.
I'm just coming the policy. Kindly come to my report.
Yes.
Page 11. Page 11. My lord, last paragraph. It has been now decided that it is, my lord, 2003 circular.
Page 11.
Page 11 R2 2003 circular. Have you lordship got that? in that circular, several things has been stated. Last paragraph, it has been decided that henceforth the principles of ceiling limit of
No, 1
5%
second, 1 second.
vacancies,
First, you show me the provision for compassionate appointment.
recruitment procedure for subject, recruitment procedure for appointment of next kin of departmental deceased workers, retired medical grounds, such and such. For now, these things, the relevant portion is second paragraph.
No,
1, 2,
no,
3, 4,
wait. First,
I
you
will not.
show me. First, you show me that you will provide compassionate appointment. That where is that provision?
Second paragraph, fifth line.
The existing scheme.
No, yes, my lord, that fifth line.
You read the first from
This
the
existing scheme of appointment of next kin or kith of departmental workers under the above mentioned scheme have been reviewed in the light of the ruling contained in the various judgments and instructions of Government of India for considering the case of compassionate appointment. It has been now decided that henceforth principle of ceiling limit of 5% of vacancies earmarked for the direct recruitment at the entry level post for appointment on compassionate ground under various labor system as already applicable. As already applicable in the case of employees of corporation. 5% means, suppose the entry level post is 10, 5% is reserved for the compassionate appointment. This was the circular prevailing at 2003. Now, you'll see again, you'll see kindly come on the second page, page 12. The sanction strength.
So then,
what that the compassionate appointment in the case of departmental labor can be made up to the maximum of 5% vacancies falling under the direct recruitment quota. The appointing authority will hold up to 5% of vacancies for appointment. The sanction strength as on 30th November 2002 and the laborers in position against the Court of Handling Ancillary Labours on 13th November 2002 will be taken as a taken to be calculated a vacancy earmarked for such and such. That was the vacancy. Now let us see kindly come. There was going on in next paragraph, page 13. Up to 2013, this system was going on. Now I am showing you, lordship, procedure for appointment of compassionate ground on legal or departmental workers who died or was spot. Page 13, one of these the subject. Now you will see kindly come to the second one. The laborers unions have been demanding, that is that FCI to approve such cases compassionate appointment who died on a spot within regional zone concerning instead of ceiling limit of 5% of total vacancies, such and such. Same thing is going on. Now you will see changes have come in 2008 also. Now 2015 you will see kindly come to page 15. Page 15. Page 14 you will see kindly come to 2008 was going on. Now page 15. Proposal for declaration of departmental labor as dying cutter regarding. Please refer to the FCI later number such and such on the subject mentioned above. In this regard, to inform me that department has examined the proposal of FCI regarding the declaring of departmental labor as dying cutter. The same has been accepted by the ministry. But this was going on. You have to kindly come to paragraph. Now this was going on since 2015. You will see, I am asking, praying before your lordship to come to the paragraph number.
No, sir. Kindly take this date of this communication.
2020. Now, before that, I am just going paragraph 9, page 5 of the report. Kindly come. That is very, very important. The situation changes has been described there. Supreme Court, the order of the judgment, court judgment is referred here. Please kindly come to paragraph 9, page 5.
Yes.
Page 5. That since 2015, the situation of compassionate appointment with regard to departmental labor has got changed. In an PIL matter being 84 of 2014, the High Court of Judiciary of Bombay Nagpur bench, considering the huge damages being suffered by FCI in clearance of railway wagons on the existing labor system, has been pleased to pass an order on 2011-2015, thereby passing entirely the following directions. The Government of India shall also take a decision regarding abolition of the system of departmental laborers in a phased manner or absorbing their service in other establishment as recommended by the High Court Pay Committee. The above judgment-
Accepted.
But-
I accept that.
15 simmer, there are 15.
When dying cadre was
15, there was a ban, but the matter went to the Supreme Court. Supreme Court has not reversed the judgment. Thereafter, FCI sent a proposal to the government. Government has accepted the proposal. Ultimately, in 2020, the ban has been imposed. But there was a complete ban in 2020. This ban is still going on.
yes, that is why I am saying, Mr. Chakraborty, the law relating to compassionate amendment is the date of the death of the employee, which is 2019.
2019.
Immediately within 1 month, he applied.
Well, 2015.
You chose not to do anything. You just kept it pending.
No, not kept it pending. 2015, there is a Supreme Court judgment. The order of the Bombay High Court Division Bench judgment PIL matter says that no further, you just phase-wise write up the developmental cadre. Therefore, FCI couldn't do anything. FCI now taken steps. The matter going on intergovernmentally. Ultimately, central government has taken up the matter, has made a complete ban.
But finally, your complete ban came in 2020.
But my lord, we cannot ignore the observation and judgment of the Nagpur bench, Bombay High Court Special Bench. Therefore, my lord, we couldn't do anything since 15. But in 19, he has died. Then, my lord, the ban was the Supreme Order, the court's judgment was there. My lord, the ban is there. Now, my lord, I am also now, my lord, you'll also kindly see the present position of the governmental level.
Produce the judgment.
I shall produce the judgment. I shall
come on the next day.
I shall produce the judgment.
Bring the Bombay High Court, bring the Supreme Court. You give it to him also, let him also read and come prepared on that.
And in the meantime, there are several meetings held, my lord, where they say that this issue is kept pending.
He is not denying that. Pendency is not denied. He is saying pendency because of 2015 judgment. That is his submission. He is also admitting issue was pending. But you consider Bombay High Court judgment, you consider Supreme Court and come back.
Other matters, I shall give you one copy. Well, I shall produce one copy of the judgment, my lord.
Both Bombay High Court and Supreme Court.
Supreme Court, one-page judgment, Supreme Court says.
All right, bring that. Ashu. After hearing the parties, it appears to this court that the relevant judgment of the Honorable Bombay High Court and the Honorable Supreme Court are required to be placed before this court. Mr. Kamal Chakraborty, Learned Counsel for FCI, submits that on the next day he shall produce the judgments. The writ petition shall appear under the heading Kishe ache?
For orders. For orders.
For orders. On November 10, 2025.
Sufficient time, my lord, I shall produce that.
But can it be before the vacation? Well, compensable, can it be before the vacation?
November 10.
I shall.
You may try your luck before elsewhere also. I'm coming within 10 minutes.
Then I'm
Last occasion, my lord, I directed them to file the affidavit showing compliance of the orders. But what has happened, my lord, my pension pay scale was fixed by an order dated 9th May 2008. That was challenged by me, and that order was set aside. And now I am only file this writ petition for complying the revised pay scale and compliance. They have filed. They have given to me service. I have filed. I have prepared a
compliance.
No, I
Why?
have prepared a reply. They are still adamant on that order dated 9th May 2008. The revision of pay scale will have to be changed because the 9th May 2008 order has already been set aside by this honorable court. The pay scale has to be revised now, but they are not doing it.
Yes, Mr. Paja.
আমরা বলেছি তো ওই তো দিয়েছি তো দুটো পে স্কেল হোয়াট ইজ দ্য এফেক্ট অফ দ্যাট এই 2008 এর অনুযায়ী কি এফেক্ট
If my lord sees the impugned order once 9th May 2008, that is at page 21
of the writ petition.
Of the writ petition. There in clause 1, it has been said that the date
21.
Yes, page 21.
This was set aside.
This was set aside.
Yes. Show me the set aside.
Set aside order is at page 23. Operative portion is at page 25. Operative portion, page 25, last paragraph.
Payment directed.
Yes, that was given. That they have given.
That payment made.
That payment has.
So they accepted.
Yes.
They also accepted that.
Yes, they have accepted the order.
But they have not revised the pay scale.
Not revised the pay scale.
Why?
Now, in the impugned order, once I can clear the confusion that is occurring. In the impugned order, that page 21. Page 21.
Yes.
Page 21, clause 1. The promotion in the same post of assistant chargeman and pay fixation thereon in the same pay scale number 9 with effect from 22nd July 1999 shall be treated as infructuous as he has already been allowed the benefit earlier with effect from 1/2/99. This has been set aside.
You want this implementation of this?
Yes. Now
So
set aside.
if that's right. So if this is set aside, so the clause 1 revives.
Yes, pay scale will be revised.
Yes.
Clause 1 and clause 2 also. Clause 2, they have said that
Yes.
Yes. You've done it. No.
Take the microphone.
রিভাইজ করে কোথায় বলেছি বল?
When you will revise, tell me.
Yes, I am drawing your lordship attention that. কোথায় জানো ওটা যে আছে ওটা? আমাদের কোথায়? হ্যাঁ? কোথায় জানো আছে ওটা? হ্যাঁ, সেটা কোথায়?
The effect of that order. সুতরাং এই ক্লজটাকে এফেক্টই করছে সেই জন্য ইনফ্রাকচারাস
Your lordship, will your lordship kindly allow my junior to say, to make, because he is well acquainted with the fact.
Lord, may I place first the order which has been set aside? What was the order? The first order is that the promotion in the same post of assistant chargeman, LNH, and pay fixation thereon in the same scale of pay 9 with effect from 22/7/1999 shall be treated as infructuous as he has been allowed the benefit of earlier, that is with effect from 1/2/99. Therefore,
If this is set aside,
then what is this clause? He has given benefit, ought to given benefit on 22/7/99. But he has given benefit on 1/2/99 prior to 22/7/99. That's why the order says it has been infructuous because he has already given effect.
but you have to give him this
Yes, from 22nd July.
with effect from 22nd July 1990.
Yes, I am coming there. Therefore, he has given effect to 22/7/99. Secondly, as
No, first, this is no secondly. So you have to give him with effect from 22nd July 1999.
therefore, my lord, 22nd July is subsequent. That's why we have deducted from his terminal benefit, which we have done. 22/7/99 is subsequent to 1/2/99. Already he has given that scale 1/2/99.
But this has been set aside. What is the effect?
Therefore, he ought to get 22/7/99. Therefore, he has given excess some amount because he has given scale of 1/2/99.
But the moment it is set aside, your clause 1 is also set aside.
Yes, I am coming. We have given effect too. That's why, my lord, kindly see our compliance report, where we have given two different.
You have checked up the compliance
Yes,
report.
I've checked.
Yes.
They have not increased my amount. My amount will be increased as per the clause 2 also. The clause 2
May I come in? May I come in? Kindly see page 19 of my compliance report. Page 19.
Nine.
Heading change in pay as per order dated 9/5/2008. Therefore, my lord, if that order is implemented, then that will be. Kindly see on 1/2/99, pay scale has been changed as per that order.
Elevated to assistant chargeman.
Yes. But that order has been set aside. Therefore, he has to given back the earlier stage what he has, my lord, asked for. Now, my lord, next page, we have given that calculation as per the PPO per service after court
Sir,
order.
the moment that order has been set aside, you have to accept that there is no 9/5/2008.
Yes.
So had there been no 9/5/2008, what would have been your duty?
20, page 20 I have given.
20.
Page 20. 19. Next page. As if there is no order of 9/5/2008. It will be the change of his scale. He did not deny it.
And you have given this scale.
Yes. And
Yes, Mr. Counsel.
Yes. I will kindly see in page 20, they are increasing.
You have considered this.
I have considered 1,150 rupees will be increased in the pay scale.
Let them say.
I have already stated in my affidavit in reply. They have not checked up.
No, they have stated in affidavit in reply, my lord.
Show me.
2003.
No. Come to page 20.
2009, ROPA 9 will have to be applied to the petitioner. That was introduced in 2007. That has not been applied.
ROPA 9, he has returned in 2007. How ROPA 9 will be applied?
1st January?
Yes.
2000? He has retired.
On 31st October 2007.
31st October.
ROPA was
9,
introduced.
He has in the affidavit in reply, he has stated ROPA 2003 has not been properly effective.
ROPA 9 I have said, not ROPA 3.
Show us his reply.
ROPA 9.
Show us.
I have attached only one paragraph. Para 4, I have already stated ROPA 9.
Para 4, page?
Page 3.
Yes.
I have never said ROPA 3. ROPA 9. They have not considered it and they have not.
come on the next day, consider this. If you find there is any miscalculation on your part or misunderstanding on your part, rectify it, give the effect, come back and file a short affidavit that we have done that.
Yes.
এটা ভুল হয়েছে
না রোভার 31st রোভার 7 এ হয়েছে, এইটা এফেক্ট হয়েছে কিনা এটা ওটা ওর এফেক্ট আসছে কিনা সেটা
I would kindly keep this within a week or two because my lord, the petitioner is already age 78.
ফার্স্ট 23 থেকে
Mr. Your name?
Sujit Banerjee.
Sujit Banerjee, learned advocate, appears for the petition. Mr. Shumit Panja, learned advocate with Mr.
সুমিত রায়।
Same name.
Mr. Shumit Rai.
Not same age. No, obviously. Same name.
Shumit Rai, learned advocate, appears for the electricity distribution company. The core content paragraph, the core contention of the petitioner now is that petitioner claims the benefit of ROPA 9 as pleaded in paragraph 4 to the affidavit in reply. In the facts and circumstances of this case, and taking into consideration of the fact that the office order dated May 9, 2008, annexure P4 at page 21 to the writ petition having been set aside by a coordinate bench, by its order dated April 4, 2024, annexure P6 at page 23 to the writ petition, whether the petitioner has been granted the relief to which he is eligible to in accordance with law. Ki bollam?
আফটার 31st নিতে হবে, আমি ফিরবো তো 1 তারিখ। এটা হচ্ছে 30 থেকে 31 থাকবে।
The distribution the electricity distribution company shall check its record, shall verify its record by whether verify its record and to find out whether the respondents shall revert back to this court on the next date. Paragraph. If it is found that the benefit to which the petitioner is eligible to, as claimed by the petitioner, has been granted, the respondent shall file a compliance affidavit giving the details with supporting documents on the next day. The writ petition shall appear on
দিয়ে দেবে তো, সেই ডেটে যদি ওর ভেতর পড়ে না তাহলে যেদিন দেবে সেদিন কি আসবে।
না তুই থাকবি না বলছিস তো,
আজকে কত
পিরিয়ডে থাকবো না, যদি ডেটটা পড়ে দেয়
August 27. August 27.
তাহলে সেই কথাই তো বলছিস আজকে, তুই ওকে আটকাচ্ছিস।
up to 1st September I shall be out of station.
Up to 1st September.
23rd to 1st September.
And 1st to 15th, this bench will not be there in circuit. So 23rd, আজকে কত তারিখ?
ছেলের কাছে যাবো।
আজ কত তারিখ?
13th.
So let there be a shorter time. You are not there since
23rd.
23rd. You filed by 20th, 7 days. The petition shall appear under the heading kishe ache for orders on August 21, 2025.
Deeply obliged, my lord.
একটু আস্তে আস্তে হচ্ছে আর কি, খুব একটা ঠিক আছে তা না।
There is a direction for filing report in the form of affidavit by the state. There is a report.
Exception?
Not, it was allowed. It goes in her favor.
So nothing survives in the
Writ petition is a different footing.
Not survive.
It's a temporary relief has been granted by the authority. But here the petitioner is a lady health assistant. As per law, a lady health assistant should be posted in her home district. Is vacancy are available? If not available in the vacancy, then nearby district. These are the law. This law has been settled by this honorable court. Several judgments I have annexed in the writ petition also. In this case, the petitioner's residence is Malda. In spite of so many available vacancies, she was posted in Nodia, more than 100 kilometers away, while she is residing alone with her minor child. She has undergone and severe operation, heart operation, and machine has been installed in her heart. Since she was posted in different districts in spite of vacancies, we approached the Director of Health Service. She instructed my client to apply for transfer. They will transfer me. Initially, I applied for transfer. Thereafter, I approached this honorable court. This honorable court, when the state respondent took a completely contrary plea that she is not eligible for transfer. That's why that application was disposed of. Subsequently, I have challenged that they are posting. I paid for my posting as per law. During the pendency of this writ application, they have temporarily posted me. My case is why temporarily? As per law, I am entitled to post in my home district. As in the report, they have submitted that they have temporarily posted.
Show me temporary.
My lord, may I just place the page 2 of my affidavit, very concise. May I just place 2 or 3 paragraphs. Paragraph 4. May I just read?
Is this the order? Page 4?
Page 4, my lord.
Page 4.
There is no temporary term used.
It has been hereby detailed to work at subcenter in the same capacity under CMOH Malda.
That's what particularly says. Detailed means a temporary.
The reason, there is a reason why, my lord. My lord, kindly, my lord, may I just.
What is the meaning of detail to?
Detail means that's for the time being, considering the exigencies regarding this medical conditions, he has been posted there. Now the whether that
how long this employment is valid?
That depends, my lord. That this farm that the nomenclature they use it as farm posting. That, my lord, the problem is that
no. How long this employment is valid?
This employment, it's a post of health assistant.
It's a government service.
Government service under
regular government service.
Government service. Now, my lord, kindly, my lord, sees that page 2, that it is a fact that the health assistant female, it should be given the first appointment in home district, subject to availability of vacancy.
20
Yes. So home district, that vacancy was not available.
Malda
not available. So she was accommodated in Nodia. Now that question comes.
Malda is not near adjacent to Nodia.
Nodia. My lord, as per the availability, she has been posted there. Just appointment has.
Now again she has been.
Now, yes. Now he has been posted to Malda. Now the problem is that the precondition is that subject to availability of vacancy. So now the question after she has joined the post, question of transfer. she has the transfer is applicable in her case, but after completion of 3 years. That 3 years she has not completed after 2024. So now after this reapplication, these 3 years have not complete. Still, they have accommodated the petitioner and the near. But in future they can consider. But as of now, since contemporary other applicants, other senior, they have also applied for the Malda.
Mr. Bari, is this the rule? What he is saying? The 3 years you have to work first?
That is for transfer. I am not praying for transfer. I prayed for my posting.
But posting was not available at that
But
time.
posting, if it is not available?
And not a single candidate was appointed in the district of Malda. So many vacancies were available.
So,
yes.
Well, these vacancies they have temporarily posted. This vacancy was there. This vacancy was there where she is now posted.
Yes, in my case, that's the thing, that contemporary other applicants and senior, they have also applied. But since his medical conditions, she has been now accommodated.
If you have a vacancy, why don't you appoint?
That the seniors and other who have applied first prior to her, now they will be saying that how keeping our applications pending, she has been accommodated.
So better you work there.
That in future,
the way you are working, you go on working.
My lord.
I'm keeping this petition
Very
pending.
Very well. Very well. My lord, I am working there.
The moment you will be shifted, you will come
My lord.
by an interlocutory application.
Very well. Very well.
But if it takes some long time for this period, so it will be kept pending and it will be
no issue.
No issue. No issue.
No issues. Ashu. Following the rules, Mr. Shamimul Bari, learned advocate, appears for the petitioner. Mr. Shumon De, learned state counsel, appears for the state. With MS? Kulpita Pal, learned advocate.
Sorry.
The solitary grievance of the petitioner is that the petitioner was appointed as
health assistant female.
Health assistant within bracket female at Nodia. Whereas the home district of the petitioner is Malda. The relevant rule says the home health assistant bracket a female has to be posted and appointed at her home district. And if no vacancy is available there at the time of posting / appointment, then the adjacent districts.
Nearby.
Then the nearby district. Nodia admittedly is not a nearby district and or adjacent to Malda. Paragraph. On the health issue, along with other grounds, petitioner applied for transfer at her home district, claiming a posting at her home transfer, claiming a posting at her home district at Malda. By an office order dated June 25, 2025, Annexure R1 at page 4 to the report in the form of affidavit filed on behalf of respondent number 2, কি বলুন
অপোজিশন হলে বলতাম, দেখেছি তো ওই জন্য বলতে চাইছিলাম যে জয়েন করে অফিস করবো
25 এর পর কমা, তারপর অ্যানেক্সার।
এখন এখানে যখন করা হয়েছে ওই জায়গাটা বলা যাবে না, পরে হয়েছে কি করবো, দেখ এইগুলো একটা বিশাল।
The petitioner has been posted at Malda at a subcenter at Malda, at a subcenter at Malda. And the petitioner has been detailed to work at that place. দিদি কোথাও যদি অসুবিধা হয় আমার সঙ্গে সঙ্গে থামাবেন, আপনি যতবার খুশি থামাবেন, কিন্তু না বুঝে বেরিয়ে যাবেন না, হ্যাঁ? আটকালে থামিয়ে ঠিক করবেন। Paragraph. Mr. Bari, learned advocate, appearing for the petitioner, submits that the petitioner claims permanent posting at Malda in accordance with law. After considering the rival contentions of the parties and on perusal of the materials on record, it appears to this court that the petitioner has now been posted at her home district at Malda, where she has been working.
Petitioner is apprehending that she may be posted elsewhere. Well, lordship can record it.
কি বললাম? না একটু আগেরটা পড়ুন। মিস্টার বাড়ি কি বলেছে? And he expresses the apprehension of the petitioner that she may be further reposted, oblique transferred to elsewhere in other district. Full stop. তারপরে বলুন after considering. Full stop. Fine. In the event the state authority takes any further decision, to change the workplace of the petitioner, the appropriate authority of the state shall serve at least a prior 30 days notice to the petitioner.
That will serve the purpose. Or lordship can indicate the without the leave of this honorable court. Then the writ application will automatically come.
Let me abide by the.
Not abide.
কিছু রইল না, এডিটটা আমি I can dispose it of here and now. 30 days notice sufficient. You will have a right to challenge them. 30 days notice.
Apprehension
Then,
that.
my lord, then observation may be deleted and lordship can dispose it of.
What I'm thinking, my lord, no,
no.
what he has submitted, I just
apprehending that
they're just he's just opening this option to the authority that they can transfer. There is no idea as of now
As
that
of now, yes.
yes, there is no idea.
তা কি বললাম?
They will be getting this action.
আগে এগিয়ে আসুন তো উপরে মিস্টার বাড়ি।
Submission.
পড়ুন পড়ুন। তার আগে মিস্টার বাড়ি বলেছি যেখানে পড়ুন। So claims permanent posting at Malda in accordance with law. Full stop. আর কিছু লিখতে হবে না। আর কিছু লিখতে হবে না। তারপর বলুন। Paragraph in the event. ঠিক আছে পড়ুন।
In the event that portion is there.
It remains.
Yes.
Full
Very
stop.
good.
30 days notice.
Very good.
Full stop.
Well,
Time.
that will serve the purpose.
Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. By the respondents.
করতে পারি যেটা ভালো
With the above observations and directions, this writ petition, the bold hai hamar, WPA 10901 of 2025 stands disposed of, comma, without any order as to cost.
That particular language your lordship have used in the event they take any further steps.
এটি চেঁচিয়ে পড়ুন তো দিবি।
But in the event they take any further steps, only that person.
No, I have said so.
Very well. Very well.
Sure.
As your lordship. Deeply applied. Lordship have disposed it of.
Lord, 11,
I
I'm
have
back to appear for the petitioner now. Lord, in pursuant to the, my lord, earlier direction of your lordship, my lord,
I am appearing for the Union of India.
I have handed over the copies of the writ petition.
Huh?
In pursuant to the, my lord, earlier direction, my lord, I have, my lord, served the copy of the writ petition, my lord, upon the respondents.
Yes.
The second round litigation, my lord, the petitioner here in my lord, challenging the impugned order.
Where is the report? Provident Fund? Filed.
It is ESI matter, my lord.
ESI matter. My lord,
Not a
earlier
provident,
occasion,
it is ESI.
the ESI authority, my lord, filed their report.
My lord, in compliance of the order passed by this by the coordinate bench, my lord, when remanded back the matter before the authority concerned, my lord, an order has been passed that is at page 38, my lord, of the writ petition, which they have challenged, my lord. This
report of file করেছে।
But in this writ petition, report was directed to be filed.
They have filed.
earlier,
Earlier occasion, they have filed. One, my lord, learned advocate, Mr. T.K. Chatterjee, my lord, he has filed the report on.
T.K. Chatterjee.
Yes, my lord.
T.K.
My lord, my exception also is ready. May
Yes.
I file it, my lord?
Ashun. Affidavit of service filed in court today is taken on record. On the prayer of Mr.
Gaurav Ghosh.
Gaurav Ghosh, learned advocate, appearing for the petitioner, the exception on behalf of the petitioner filed in court today is taken on record.
Well, I'm handing over the
Mr.
copy.
Amit Chakraborty, learned counsel, appears for Union of India. Mr. Shiv Chandra Prasad, learned counsel, appears for respondent number.
ESI Corporation, my lord, that's the respondent number. My lord, 2, 3, 6, 2, 3 and 6.
/ ESI authority. Yes.
Matter relates to, my lord, assessment of disability of the petitioner. What has happened, my lord? The petitioner was an employee. My lord, he met with an accident. And my lord, after the accident, he lost his earning capacity. Now, my lord, challenging.
Medically assessed.
My lord?
Medically assessed.
Medically assessed by the respondent authority, my lord. Kindly come at page.
Show me the assessment report.
Yes, my lord. Page 27. Page 27, annexure P4. This report has been, well, the
assessment has been done by the ESI authority, my lord.
Medical board of the ESI.
Medical board of the ESI authority. Respondent. Now, my lord, they have
Page, you are a party to that?
No, page 27.
Page,
page
page
27.
27, my lord.
Annexure P4.
Yes.
Now, my lord, they have assessed me as a 20% of my lord permanent disability. Now, my lord, what has happened? I have approached the my lord district hospital Tomlu.
That is of your own.
Yes, yes. Now, my lord, the medical officer has been assessed me to the tune of 60% instead of 20. 60%. I have applied before the respondent authority, rejected my prayer. My lord, I have came before the honorable court. My lord, by a coordinate bench order, my lord, by his lordship, my lord, Justice Lopita Banerjee directed the my lord respondent ESI authority to my lord reconsider my prayer. Now, my lord, they have reconsidered and on mechanically, my lord, they have rejected my prayer, my lord. Kindly come at page 36, my lord. This is the earlier order.
Show me the rejection.
Rejection.
First, show me the Justice Banerjee's order.
Page 36. My lord, I am showing the operative portion, my lord. Last paragraph. My lord, may I read it, my lord? Page 36, my lord, last paragraph. May I read it?
Show me the order.
Now, my lord, the rejection order, my lord.
Page
It is
38.
at page 38, starting from page
Justice
38.
Banerjee's order was to the extent, since you could not avail of the review medical board, so she granted you an opportunity that go before, appear before the review medical
Review
board.
medical board. Now, my lord, they have not.
That has got nothing to do with your own report.
No, my lord.
60%
In consideration with that report, my lord.
Show me.
Yes. My lord, kindly come at page 36, last paragraph.
Yes.
Having considered the rival submissions of the parties and the material placed on record, this court directs the respondent number 3 to consider the representation of the petitioner dated May 6, 2022 and July 18, 2022, keeping in mind calculation that appears from the disability certificate dated March 25th, 2022. That is the, my lord, issued by the medical officer, Tomluk Hospital. In case the petitioner is required to be examined before a review medical board for calculation of the percentage of his disability.
So it was to be looked into,
my lord.
Then you will be assessed.
My lord. But nothing has
the
been
rejection.
done. Nothing has been done. They have only mentioned the statute and rejected my prayer.
Show me, show me.
My lord, kindly come at page 38, paragraph 4. On receipt of ESI C 154, communication of decision of medical board, the insured person submitted an application mentioning that he has been assessed loss of earning capacity in the extent of 60%.
So it is taken care of.
My lord.
60%, then the report is taken note of.
Note of.
Then.
Now, my lord, as per section 55, subsection 1 of the ESI Act 1948, any decision under this act of a medical board or a medical appeal tribunal may be reviewed at any time by the medical board or the medical appeal tribunal, as the case may be, if it is satisfied by fresh evidence that the decision was given in consequence of the non-disclosure or misrepresentation by the employee or any other person of a material fact whether the non-disclosure or misrepresentation was or was not fraudulent. My lord, that has not been fraudulently done by me.
That is not the proper provision to be applied.
My lord, then my lord, kindly come at the, my lord, the conclusion, what they have concluded at page 39. However, my lord, it's paragraph number 5, last portion of
No, kindly come to page A.
A, my lord, A. May I read it, my lord? Had the insured person produced any fresh evidence before this office in support of his claim that he had been examined prior to the date of medical board, that is before 27th January 2021, his request could have been accepted, but he failed to submit the same before the medical board members on the date of medical board on 27th January 2021. Now, my lord, I don't have that. After they have examined me, I went to the, my lord, district hospital. Now, my lord, kindly come at page 39B. He had submitted a disability certificate, white number such and such, dated 25th March 2022, issued by the Office of the Superintendent, District Hospital, Tomlu, Purbo Midnapur, Government of West Bengal, mentioning his percentage of disability calculated as 60%. See, my lord, this disability certificate was issued after 13 months from the date of medical board. Therefore, his application for reference to medical board for review has not been entertained as per extant provision of the ESI Act 1942. My lord, they have
wrong.
My lord, they did not my lord.
What wrong?
My lord, they did not ascertain, my lord, on my lord
Not
sympathetical
required.
ground. They only, my lord, by mentioning the statute, the
no,
act, my lord,
coordinate means directed as per the extent rule. And
they have not
wrong?
and they have not assessed me the present
Not required.
present earning capacity,
Not
losing capacity, my
not
lord.
required, sir. It is a medical report of the medical expert.
My lord.
Court will not
My lord,
intervene.
but if necessary, my lord, I should be, my lord, examined.
Not required. Then it will be a never-ending process.
My lord,
You will not be
only
happy.
for once.
Next time you will not be happy with 40%. You will take another certificate. You are 150% disabled.
I leave it to your
আচ্ছা
lordship.
এই দুটোর সময় আমি তো এটাই নেবো, এই লিস্টই চলবে তো? ঠিক আছে, ও একটু মোশনই হবে এফেক্টিভলি। আমি এই মামলাটা এসে অর্ডার দিয়ে দেবো। তারপর আমার এই অর্ডারের বাঞ্চ থেকে ওই বিকাশ ভট্টাচার্য সাহেবের মামলাটা যেটা উড়িয়েছিলাম ওই অর্ডারটা আমার একটু বের করে রেখে দেবো।
My lord, I'm sorry, my lord, to say, my lord, at 2 p.m., 2 matters are fixed in 2 courts, my lord.
Your presence is recorded.
I'm saying,
to be mentioned.
should I, my lord, make my submission 1 line or 2 line, my lord, now? So I can, my lord, my learned friend had chosen a wrong forum. If your lordship can take, you know,
The tribunal.
section 75. Tribunal, any disputes arising out of medical, section 75, and my lord, section 55(2). That's, my lord, we have also quoted in, my lord, this.
Yes, impure order.
Impure order.
Give me the book.
Yes, I'm giving, my lord.
Keep that.
Yes, I'm giving. My
Keep
lord,
that here.
I'm sorry, my lord, I have to, my lord.
Not a problem, but keep your book here.
Yes, that will suffice. My lord, only 2 things, my lord, your lordship. Grateful.
I'm coming then.
Great.
Yes.
Before passing the order, my lord, may I submit one more thing, my lord? Only, my lord, file text, sir. File ta, my lord, file ta, my lord. If your lordship may kindly take, my lord, order dated 7th August 2023, passed in this writ petition, my lord, by my lord Justice Lopita Banerjee.
In this writ petition?
In this writ petition, the first order, my lord.
Yes.
Lord, kindly come at page 2, last paragraph. May I read it, my lord? In the impugned order passed on December 29, 2022, in accordance with the order dated November 29, 2022, passed by this court, the AC and RD proceeded on the basis that under section 55(1) of the 1948 Act, any decision of a medical board or a medical appeal tribunal may be reviewed at any time by the medical board or the medical appeal tribunal, as the case may be, if it is satisfied by fresh evidence that the decision was given in consequence of non-disclosure or misrepresentation by the employee or by any person of a material fact. Now, my lord, this court is
Decision was given in consequence of non-disclosure
or misrepresentation by the employee or by any person of a material fact.
So that is not your case.
No. Now, my lord, next paragraph. This court is prima facie of the view that there was no non-disclosure or no misrepresentation on the part of the petitioner.
As I said.
My lord, this court cannot comprehend why the AC and RD decided that had any evidence been brought by the petitioner prior to January 2027 to 2021, to January 27, 2021, the same could have been accepted, but since the evidence was brought after January 27, 2021, the said evidence cannot be considered. The question of review would not have been arise if the documents would have been produced before the medical board or medical appeal tribunal before the date on which they assessed the loss of earning capacity of the petitioner insured. The question of review of a decision can only arise after a decision has been taken by the authorities concerned. Now, my lord, under section 55(2), my lord, my lord, explain the sections, my lord. At page 4, my lord, kindly come.
But you have not approached before the tribunal.
No, that has been, my lord, already looked after in earlier writ petition.
You have not been approached, no.
That
the earlier writ petition said,
my lord,
to consider,
my lord,
if any fresh material comes.
found.
Fresh material was not available because your certificate from the other district hospital was also there before the earlier writ petition.
Earlier writ petition.
Right.
Yes.
So in the earlier writ petition, your certificate of the district hospital was there.
There, my lord.
So it was not a fresh evidence.
No, but
it was
my
not.
lord, authority concern, it is fresh evidence. They have not considered my evidence, my lord. After, my lord, they have taken into consideration that I have lost my earning capacity to the tune of 20%. They have not considered it, my lord.
Then it was not there. First, they considered and assessed 20%.
20%.
Then you went to district hospital.
Yes, my
that is the subsequent stage.
Subsequent stage.
And then you got it 80%. Or 60%, whatever. 60%. I'm so sorry. 60%.
60%.
So that is not a subsequent event. I'm sorry.
This is a subsequent event, my lord.
This is a subsequent event.
Yes.
This is a subsequent event, but not subsequent to the medical report.
Yes.
Medical board.
Medical board. By the, my lord, constituted by the respondent authority.
Absolutely. Now, my view is it's a never-ending process. District hospital, you have gone, obtained 60%. Today, you go another hospital, you will get a certificate of 80%. It's a never-ending process. The moment and selecting authority has framed its medical board, they are all medical experts.
My lord.
So unless clear perversity or malafide is there, It should not be interfered with. Like I tell you, in Assam Rifle examination, bunch of repetitions. Whenever it comes to me, lock, stock, barrel, I dismiss. Lock, stock, barrel. In 3, I gave the interim order. Why? There are provision for first medical board. If they are aggrieved, then review medical board. Right? First medical board, candidate was disqualified, let's say, due to his eye problem. On the basis of that, when appeal was preferred, review was preferred before review medical board, I খুলবেন না কিন্তু অমিও খুলবে না বুঝেছো ওই ফাইল শুদ্ধ দেখাবে খুললে হারিয়ে যাবে then when on the basis of that they went before the review medical board did not consider that eye factor. He said no, he is disqualified because his complexion is dark. I'm giving an example. So 2 different views. It is a fit case for reference before a third hospital. So I referred it to Alipur Command Hospital. So I referred it to Alipur. But the moment, had it been a case that first medical report says due to eye defect it is rejected, review report also says it is eye defect which is rejected. No interference.
My lord, they have rejected my prayer only because of, my lord, I have not approached the, my lord, review medical board. After getting that 20%, I have not approached by the statute. That is why, my lord, my
So
prayer
that is
was,
one ground. Fair enough. You had a statutory remedy.
but my lord, now I don't have any.
That's right. But this selection process cannot go on forever. Acha. Next, I dismissed a writ petition, lock, stock, barrel on the ground. The final merit list was published in December. And after that date, whoever have come with the writ petition, lock, stock, barrel dismissed. Because the panel was completed.
What I humbly beseech your lordship, my lord, they should have considered my lord, prayer only.
They considered and found it to be defective as 20%.
Yes, on a, my lord,
Matter
but there
ends.
is a contrary, my lord, report.
Contrary, that you can go and take from another hospital. That's what I am saying. It will be an open-ended process, never ending.
I leave it to your lordship, my lord, as your lordship may please.
Suppose on the basis of your report, second report, I say go and get it one more examination. One more examine. Another report will come. It will say, let's say 70%. Your client will not be happy. He will take another report from another hospital, 95%. This is not permitted.
Pursuant to the, my lord, earlier direction.
And 3 matters went up to appeal. 3 matters went up to appeal. From the interim order, it was not interfered with. And dismissal also not interfered with. It cannot be done. Because Vachari Saheber judgment দেবে দাও তো ফাইলটা It cannot be done. It's a never-ending process.
I'm only asking for once. That is one asking, my lord.
If I give you once, why I will not give others once?
That is up to your lordship, my lord. That I cannot say.
Selection process cannot remain open for eternity. There has to be a full stop some point. Ashun. When this selection process has been over?
Not having, my lord, Mr. Prasad is on legs, my lord. That's why, my lord, I'm not having the brief. Otherwise, my lord,
I have assessed 20%, my lord. on,
No, that is not this panel.
it's not a panel, my lord. I have made an accident.
খুলে দিলে কেন?
Disability.
হ্যাঁ? But you have tried your best. Mr.
Gaurav Ghosh, my lord.
Gaurav Ghosh, learned advocate, appears for the petitioner. Mr. Amit Chakraborty, learned counsel, appears for Union of India. Whose name will be there?
My lord, Mr. Prashad.
Senior.
My lord, as I am not in the panel also, my lord, so it is better.
Mr. Shiv Chandra Prasad, learned counsel, appears for
ESI Corporation.
ESI Corporation.
ওটা লিখেছি বোধহয় আগে whatever ESI ঠিক আছে লিখেন ESI দেখুন The petitioner at all material time was an employee in the PS Earth Movers Limited, Private Limited, bearing an employee code. দরকার নেই full stop. In course of his employment, the petitioner has suffered an accident and the medical board of the ESI
Yes, ma'am.
Yes, ma'am.
has assessed the disablement of the petitioner being
20%.
20%. Annexure, comma, annexure P4
Page 27.
at page 27 to the writ petition. Paragraph. Immediately the petitioner went before a district hospital, a district government hospital at Purbo Medinipur, where he had been assessed to be disabled 60%, to be physically disabled 60%. Full stop. The disability certificate was dated March 25, 2022. এখানেই মামলা শেষ এটা করে দিন J2 is annexure P5 at page 28 to the writ petition. Paragraph. The ESI regulation and norms paragraph provides for the provisions of the ESI the ESI regulations oblique norms provides for an appellate oblique review remedy. Comma, admittedly, the remedy from the decision of the ESI medical board. Comma, admittedly, the petitioner chose, petitioner has not availed of such remedy. Mr. Chakraborty, you please take your seat. Poster. কি বললো? Poster. In this backdrop, a previous writ petition was filed, WPA 24729 of 2022.
629, my lord.
Huh?
629. 24629.
তোমার প্যারাগ্রাফ 10 এ কি লেখা আছে? WPA 24729.
Pardon me, my lord. 629.
629. আচ্ছা 629.
Page 35, my lord.
Order.
Yes,
629.
Page 35.
629. কি বললাম? প্যারাগ্রাফ এটা দিদি। কমা A coordinate bench by an order dated November 29, 2022. Annexure P7 at page 35 to the writ petition. Full stop. Under the said order, the coordinate bench had directed as follows. Quote 1 from page 36. Paragraph. Pursuant to and in terms of the said direction of the coordinate bench, the ESI authority has passed its impugned reasoned order dated December 29, 2022, Annexure P8 at page 38 to the writ petition. Under the said impugned order, the ESI authority has held that since there has been no fresh evidence available on the issue, And since the petitioner did not avail of, the remedy is let down under section 75 and subsection 2 to section 55 of the এই যে দিদি এই পুরো একটা লিখে দিন 1942 for short the ESI Act. The request of the petitioner was not accepted. And accordingly, the said assessment of the ESI Medical Board assessing the petitioner to be disabled by 20% has been confirmed, has been affirmed. What are you on page? 20%. Post. Paragraph. Mr. Shiv Chandra Prasad, learned counsel for the SI authority, submits that the remedy provided under the statute not being availed of, the petitioner cannot challenge the decision by way of the instant writ petition. He further submits that the finding of the Medical Board of ESI has not been controverted by the petitioner by producing any subsequent evidence later than July 6, 2024, being the certificate of the district hospital, district government hospital. Post. Mr. Prasad prays for dismissal of this writ petition. Sir, what do you say, Mr. Chakraborty? If you have any submissions?
Yes, sir. Mr. Prasad is appealing for the yes, sir.
Post. Paragraph. So you are adapting his submissions.
Yes.
Paragraph. Mr. Amit Chakraborty, learned counsel for the Union of India, has also adapted the submissions of Mr. Prasad. Paragraph. After considering the rival contentions, rival contentions of the parties and on perusal of the materials on record, it appears to this court that this writ petition was initially considered by a coordinate bench on August 7, 2023. And pursuant to the direction made therein, the parties have filed their report on affidavit and the exception on affidavit thereto. Paragraph. The materials on record shows that the medical board of ESI assessed the petitioner to be 20% disabled on July 6, 2020, July 6, 2021, at page 27 to the writ petition. And the petitioner thereafter on March 25, 2022, obtained a medical certificate from the district government hospital showing that he is 60% disabled. When the first writ petition was filed, when the previous writ petition was filed, and the order was passed therein on
29th,
November 29, 2022, both these reports were there before the coordinate bench. And upon considering those reports, the coordinate bench passed its order. Thereafter, no subsequent development has taken place, nor any new material has come on the field. Post. On the basis of those two medical certificates, paragraph. Pursuant to this said order dated November 29, 2022, the impugned reasoned order has been passed. On December 29, 2022, at page 38 to the writ petition. The impugned reasoned order shows that both these medical certificates, as referred to above, were taken into consideration and the impugned order was passed. No fresh evidence was produced. Poster. Admittedly, the petitioner did not avail of the statutory remedies available to him under the ESI Act. Full stop. Paragraph. The report of the medical board, paragraph, the report of the medical board of the ESI is an expert's এসটা শেষে apostrophe, এসের পরে apostrophe, is an expert's opinion. The law is well settled that court cannot sit in appeal on a decision and opinion of experts. Neither the court can substitute an expert's opinion. The said expert's opinion of the ESI medical board could have been challenged by the petitioner by availing of the statutory remedies provided under the ESI Act, as already discussed above. But the same has not been done. The court seldom interferes with an expert's opinion unless an ex facie malafide, arbitrariness or inconsistency is there on the face of the expert's opinion. Apostrophe S. Full stop. This is not such a case. Full stop. Paragraph. Inasmuch as if this practice is accepted by the court, that whenever and wherever a person is aggrieved by the opinion of one medical expert and obtains a second report from the second medical expert, second different medical expert on the same issue, and on the face value of it, if the first report is interfered with, then it will be a never-ending process. Which is not permitted in law, which is not permitted in law. Paragraph. In view of the foregoing reasons and discussions, this court is of the firm view that, this writ petition is devoid of any merit. Full stop. Paragraph. Accordingly, this writ petition
14228.
এই এটা লাগিয়ে দিতে এই ক্লিপটা ঠিক করে লাগিয়ে দাও accordingly this writ petition being WPA board 14228 of 2023 stands dismissed, with or without? without any order as to cause. No, but he fought very well.
I'm grateful, man.
He fought very well.
I'm grateful, man.
Yes. Sorry, next time in a better situation.
Great.
Yes.
My lord, we are hardly getting this sort of court, my lords.
Next.
Your Lordship, I am appearing for the petitioner, Your Lordship. The matter pertaining to dispute in Provident Fund, Your Lordship.
I
So,
appeal for the
release.
So before in the Lebanon
He wants
industrial
to, yes,
bench.
my lord, to group three.
Lebanon industrial bench.
Huh.
Group three.
Group 3, man. Yes. Group 3, man. Atindranath Mishra.
Atindranath Mishra, Learned Counsel, appears for the petitioner, Mr. Paragraph. Mr. Shiv Chandra Prasad, Learned Counsel, appears for the Provident Fund Authority. Paragraph. In their usual fairness, comma, both the Learned Counsel submit that this writ petition pertains to bold group dash Roman 3 of the classification list. Group থেকে Roman 3 টা bold of the classification list. Paragraph. Due to want of determination, paragraph. Due to want of determination, this writ petition is directed to go out of the list of this court and to appear before the appropriate court. Paragraph. The records are directed to be sent. Go out of this court. List কেন হবে? List মানে তো আমার কাছে থেকেই আছে. And to appear before the appropriate court. Paragraph. The records are directed to be sent before the appropriate court forthwith.
Much obliged.
Thank you so much. Next. Hey,
কত নম্বর ছিল?
who is on the other side?
And I have served, my lord, listing of the item in the monthly list, my lord.
Passed over for the day. Passed over. হুড়ুর করে ডাকুন, যারা থাকবে তখন শুনবো। চলুন ডাকতে দাও। ডাকুন
296.
Next.
301, my lord, I am for the petitioner, my lord, in this matter, my lord.
My lord, I am here for 310. My lord, in 309, I am for the petitioner, my lord. My lord,
Other respondents are there.
96.
There's only the Union of India, and I'm for the NICL.
National Insurance Company Limited.
So who is the answering respondent?
National Insurance Company.
Where is the Union of India?
My lord, actually, on last occasion, my lord, his lordship had directed respondents to file an affidavit in opposition and to the petitioner to file an affidavit in reply. They have served affidavit in opposition copy upon me, my lord, and I have also served upon them affidavit in reply copy, my lord. So today, with your lordship's leave, if they serve,
দেখি কাগজটা, but none appears for the Union. Who is for the Union of India? আসুন। আসুন অর্ডারটা লিখি, কিছু নেই তো। On the prayer of Mr.
Aditya Sen, my lord.
আচ্ছা, প্রথম লিখুন Mr. Aditya Sen, learned advocate, appears for the petitioner. Mr.
I'm appearing for respondent number 2 and 3, Mr. Aditya Jeet Able Bose. Aditya Jeet Able Bose.
এইসব আমি শুনতেও পাই না, বুঝতেও পাই না। Touch and search for respondent number.
Mr. Ranjaga, I'm respondent 2 and 3.
Respondent number 2 and 3. Give your names. Yeah. None appears for the Union of India. None appears for Union of India.
HON'BLE copy.
On the prayer of the learned counsel for the respondent number 2 and 3. Time to file affidavit in opposition stands extended till today.
Lordship, I want to file it.
Full stop. The affidavit in opposition filed today in court is taken on record.
My lord, I am also filing affidavit.
Copy has been served. Paragraph. Similarly, on the prayer of the learned counsel for the petitioner. Affidavit in reply filed in court today is taken on record. Since Union of India is not represented, Mr. Amit Chakraborty, learned counsel, who normally appears for Union of India, is requested to appear in the matter, comma, to hold the brief and to assist this court henceforth. Full stop. His appearance shall be regularized by the appropriate authority forthwith. Paragraph. Petitioner shall serve copies of the cause papers, cause C-A-U-S-E, papers, in this writ petition upon Mr. Amit Chakraborty. Now, cause papers দরকার নেই, to respondent. Copy of the writ petition. Copy of the writ petition and the orders passed from time to time, including a copy of today's order upon Mr. Amit Chakraborty, and shall file an affidavit of service when the matter shall be taken up next. The writ petition shall appear under the heading Hearing Service. In the monthly list of December 2025.
My lord, one request, my lord. I have prepared one supplementary affidavit, my lord. I have served copy upon them, my lord. May I be allowed to file one supplementary affidavit to it, my lord?
Then they will have to again file rejoinder.
Not, it is not regarding any.
Are they not required or
No,
not?
no, my lord. It is regarding one fact which was.
That's
which has
right.
been
So they have to given an opportunity.
Yes, my lord. Definitely, my lord. That.
Been served the supplementary.
At this juncture,
We haven't received the supplementary affidavit, Your Lordship.
no, he is giving you.
Okay, yeah, please.
At this juncture, on the prayer of the learned counsel for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. The supplementary affidavit filed in court today is taken on record. Copy has been served upon Mr.
Aditya G. Table Boss. I've given mine.
Learned counsel for the respondent number 2 and 3.
From the
And a copy shall also be served upon Mr. Amit Chakraborty, learned counsel for Union of India. Full stop. The respondents shall be at liberty to file its rejoinder to the said supplementary affidavit in the meantime. আচ্ছা ওর নাম কি বললো? আমি বুঝতে পারিনি। ওই নামের সঙ্গে লিখুন led by Mr. Ranjoy De, learned senior advocate. Ranjoy De, learned senior advocate. Next.
Briefly obliged.
My lord, I am for petitioner, my lord. I am filing affidavit in reply along with affidavit of service.
I've got a respondent
Which your
to pass over, my lord.
No passover. No passover.
Affidavit in reply, my lord.
Proceed.
Yes, other side.
Mr. Shamol Kumar.
affidavit opposition, my lord.
Mr. Shamol Kumar Mukherjee,
My lord,
learned
kindly,
counsel appears for the petitioner.
my lord, the matter appearing on behalf of my senior advocate, my lord, Bhudev Chatterjee. My lord, kindly allow me for some time, my lord, for
Why?
hearing. My lord, he is the senior advocate, my lord.
So
Senior counsel, my lord.
you proceed.
Today, my lord, my instruction was some time, my lord. Kindly go. File, my lord.
Next Wednesday in that event, you have.
No, I don't think before vacation I will take.
Then, my lord, I shall start. But he cannot complete.
That is no peaceful,
incomplete matter.
no piecemeal hearing. Because I have already given a note in the list today. All of you must have seen the last serial number. Then on and from Monday, motion will be given preference until further direction. Before vacation, no other matter. Only motion. এই বারে সার্কুলেট করেছেন নোটিশ অ্যানাউন্সড হয়েছে চলো আচ্ছা Mr. Shamol Kumar Mukherjee, learned counsel appearing for the petitioner. Appears for the petitioner. Your name?
Kalidas Saha, my lord.
Kalidas?
Kalidas Saha.
Shaha, learned advocate, appears for respondent number.
Union of India, my lord. Respondent number, my lord.
Union of India. Paragraph. Learned counsel for the on the prayer of the learned counsel for the parties.
All the respondent, my lord.
The affidavit in opposition and the affidavit in reply filed today in court are taken on record.
Affidavit of service, along with affidavit of service.
একদম মাথার উপর affidavit of service filed in court today is taken on record. The writ petition shall appear under the heading motions a hearing service in the monthly list of December 2025.
November. It is not our fault.
November.
আপনারা করেন না কেন আসেন না কেন বলে তো ভালো হয়ে যায় মামলা প্রত্যেকটা
monthly list of November 2020. চলুন চলুন হুড়ুর করে দাও
My lord, 315, my lord. My lord, I am for the respondent, my lord. 10 days time for filing the opposition, my lord. I am.
10-20, I don't mind.
My lord?
10-20, I don't mind. Your petitioner?
No, my lord.
Petitioner is not here.
Petitioner.
ছেড়ে দিন কিছু করতে হবে না You keep ready. চলো 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 next.
My lord, kindly it be 315. Oh, petitioner.
Petitioner, my lord. My lord, in this matter, my lord, I have questioned the procedure adopted by the district judiciary of Hooghly regarding the implementation of the Shetty Commission's recommendation.
My order is there.
Yes.
My lord, there was a direction for filing of the...
Give me that order.
For filing of affidavits, my lord, we are...
No required. Kindly see the order. My order. Give me the writ petition number.
Just give me a second.
You regular appear.
I am very sorry.
Mr. Banerjee, you should have carried it.
অর্ডারটা কোথায় গেল?
You regularly appear.
My lord, in this matter, your lordship has passed a direction for exchange of affidavits. Only the High Court administration has used their opposition, my lord, to which I have...
Look at my last order. Couple of writ petitions are disposed of likewise. Dekhi. First, see to that. If you say no, that will not suffice, then of course, whatever you say.
The 26942 of 2025 WPA.
দেখুন কম্পিউটার কে বল 26
WPA 26942 of 2024 26942 of 2024
24.
24.
Okay. 24. এটা কি আলাদা?
একসাথে। আচ্ছা এইটা দেখুন না kindly.
Is this the one? Is this the one?
My lord, analogously, 3 writ petitions were disposed of by.
This is the one.
Not this one. এইটা একবার দেখুন 24378. 24378 of 2024. 24378. তেইশ ছয় দেখুন।
23/6/2024.
My lord, this one. My lord, this one.
This one?
Yes, ma'am.
একটা প্রিন্ট আউট দাও।
এই একটু মোবাইলের অর্ডারটা একটু দেখি।
You just write the down number and you take one copy and keep that whenever this
My lord,
matter
I'll
comes.
write. কত?
দিয়ে দিন সাহেবকে দিয়ে দিন। এই নিন। Yes, Mr. Dasgupta, look at it.
হচ্ছে পাঠিয়ে দেবে for consideration before the district judge. সমস্ত objection consider করে he will pass a recent order.
My lord, it will.
My lord, may I come back tomorrow or?
No.
My lord, Mr. Ghosh is leading me. My lord, kindly for that purpose.
He appeared. Kindly look at the order. Mr. Ghosh was there?
No, my lord.
No.
Mr.
Oh.
Ghosh was
No.
not there in this matter.
In this matter.
Tomorrow তো আর হবে না, আসছে ডিসেম্বর মাসে। চলো।
Then your lordship passes over for a short pass over.
That practice I don't follow.
অর্ডারটা আপনি একটু দেখে নেবেন কি অর্ডার?
Well, kindly.
I don't mind. Passed over for the day. I have already circulated the notice that Monday onwards only motion. চলো ঠিক আছে, এটা আমার ফাইলে রেখে দাও। I don't mind in passing it over.
My lord, since High Court administration has used their opposition, I have.
The opposition, my lord, we have said the same thing that my lord, the district judiciary is
Disposed of here and now. You would have got an opportunity within 6 weeks and 4 weeks, it would have been decided.
After, I think it should be otherwise it will be keep pending.
Unnecessarily.
My lord, short pass over. Mr.
No.
Ghosh is coming from court number 13. He is just on his way.
Madam, what is not my practice for everybody, it should not be also a practice for whoever. And this is not such that the building will be demolished tomorrow. চলুন ডাকুন। It could have been done here and now.
Lordship,
Could have got the opportunity. It is passed over for the day. কিচ্ছু হবে না, ছেড়ে দিন। চলুন next.
My lord, item number 314, my lord, just the previous matter. I was running, my lord, the board even did not display, my lord.
No. Board was correctly
18,
displayed.
my lord,
I was still, my lord, 310 was there. 314 is mine, my lord. Just the previous matter.
It is nothing, no harm has been done.
No, my lord, only thing is, my lord, to place a lordship, my lord, despite my lord direction, they have not filed oppositions.
So what to do? Tell me.
If a lordship commences, my lord, may be kept in a.
Chalo, next.
318, my lord, I am appearing on behalf of the petitioner. My lord, your lordship was pleased to direct the respondent authority to file opposition
your lordship was pleased to pass the order in 8th April 2025.
So nobody is here, sir. What to do in a hearing matter? Tell me. What to do?
No,
Even the matter which was ready for disposal, petitioner was not agreeable.
no opposition has been filed.
Chalo, next, master.
20, I went to appear on behalf of the petitioner, madam. The opposition I have received and I also, madam, made a reply to this opposition, madam, matter is ready.
20. That you may hand up the affidavit in opposition.
Kilometer.
আপনি কি এদিকে যাবেন? এক নম্বর
Madam, may I be permitted to file affidavit in reply? I have already served copy.
Yes. Ashu.
Amit Shah.
একটা একটা করে হবে। রিট পিটিশনটা দিন।
ভূমিতে রিট পিটিশনটা কোথায়?
Mr.
শ্যামল কুমার দাস। শ্যামল কুমার দাস। I am for the petitioner, madam.
Shamol Kumar Das. Shamol Kumar Haldar.
No, no. Shamol Kumar has advocate on record.
Shamol Kumar Das, learned advocate, appears for the petitioner. Give your name, whatever. Mr. Ronjoy De, learned senior advocate, appears for respondent number 4226. MS Shipra Chando, learned advocate, appears for respondent number 1. You have filed your opposition, madam?
There is no such direction.
On the prayer of the learned counsel for the petitioner and the learned senior counsel for respondent number 426, the affidavit in opposition and the affidavit in reply filed by their respective clients are taken on record. By their respective clients are taken on record. Yes.
May I proceed, madam? The
Yes, sir.
petitioner was the employee of the Tarif Advisory Committee, that is the erstwhile employer. A decision was taken by the, my lord, Government of India and Regulatory Authority that the all employees serving the Tarif Advisory Committee should be joined to different national insurance company like.
Hey, Omio, আমাকে A4 paper, গোটা 20 একটা bunch করে দিয়ে দাও। Yes.
And other insurance companies by redeployment.
By?
Redeployment.
Re-employment.
Redeployment.
So all other benefits were intact.
My past service was continued and I am serving here. Now what happened, my lord? When I was initially Tarif Advisory Committee, I enjoy the, my lord, pensionary scheme framed by the, my lord, Government of India. My lord, recently 2019 an amendment came to here, wherein the serving employees were given a chance to opt for pensionary benefit. I accordingly applied before the authority, present my lord employer, that is National Insurance Company. And stipulated.
Was this scheme limited for only government employee?
No, that is.
Or for the undertaking also?
It is also in National Insurance Company, Indian and other insurance company, and also, my lord, my erstwhile employer, that is Tarif Advisory Committee.
Achha, show me the scheme.
Yes. My lord, first of all, my lord, if your lordship turn to page number 23, this is the order of redeployment of service. Page 23, that is annexer P4. আপনি বাদ দিয়ে যান।
না আমি করে দিচ্ছি, আমার লাগবে শেষে দেবে। Yes, 23.
23. This is the order of the redeployment of the service of the petitioner. April 2020, 2011.
Redeployment.
Redeployment.
Yes.
Accordingly, I join. Next page. Thereafter, my lord, a letter was issued by the respondent company that seniority, absorption, and other benefit. And my lord,
What is the ground they have taken? On what plea?
since I was not in the service of the present employer, I am not entitled.
So
Initially, I allowed. Thereafter, I deposited the money assessed by the company from contributed to my pension scheme. I deposited the money, and my lord, thereafter they rejected the only ground, since you are not in service, you were not in service, my lord.
Show me the scheme that it will permit you to be there.
Scheme
which permits you to be there. You must have claimed on the basis of some
yes
decision.
Yes. Before that, my lord, I would like to, my lord, draw your lordship attention. It's page, my lord, 28.
What is that?
28 scheme applied to the erstwhile employer. Pension scheme for TSC employees.
Sir, erstwhile scheme is not material.
No, scheme is same.
Scheme
1995 scheme originally. Thereafter amendment came in 2019. By amendment, more opportunity was given to the employee to, my lord, opt for pensionary benefit. Accordingly,
page 29.
Page 28 is the, my lord. Page 28. Pension scheme for TSC employee. That is the general insurance employee pension scheme 1995. This is dark, my lord. I am reading, my lord, to the Secretary Tarif Advisory Committee, Stock Exchange Building, that is the Bombay. Subject matter is pension scheme for TSC employees. The undersigned is directed to refer to your reference number such and such.
What is TSC employee?
TSC means Tarif Advisory Committee, that is regulated the all insurance company.
All right. Your full name, please?
Shamul Kumar.
Shamul Kumar
Das. When I was, my lord, under erstwhile employer, I enjoy the scheme, all benefit. And
so this is the principal scheme.
Principal scheme.
Dated
1995.
Date. Specific date.
Specific date, my lord.
It is mentioned. I can see, but I can't read.
There is, my lord.
26th March.
Yes. No, yes, sir. 26. This is the original scheme, 1995, introduced by the central government.
No, it is not 1995, 1996. Page 28.
28.
Read the date.
The general insurance.
It is a letter.
Letter.
So read the date.
General insurance within bracket employees pension scheme 1995 for the employees of TSC subject to the
sir, I
condition.
can't. This is the one.
No.
This is 28 P8.
This is Madhumita, my lord.
Madhumita Sen.
Madhumita Sen. Thereafter, I, my lord,
Sir,
annex the scheme, 1995 scheme.
So, all right, let us go by the annexure.
Yes.
Place the scheme.
This is the original scheme.
Yes, but I must know place it.
Yes, right.
Come to page 34.
34. 34. My lord. Clause 3, my lord. In the said scheme, in paragraph 3, after sub paragraph 9, the following sub paragraph shall be inserted, namely, my lord, join the service of the corporation or company as the case may be, before 28th day of June 1995.
Where from you are reading?
While section 3, in scheme clause,
yes,
who are entitled to of clause before 28th day of June 1995. I joined before 28th day of June 1995. Here, man, also, man, I am pausing here, my lord. Joined in the service of the corporation or a
this
company
is a notification.
as the case may be.
This is the notification of 23rd April 2019.
19. This is the amendment came. Original scheme 1995. Thereafter, 2019, this amendment.
You accept that this scheme applies?
That is the only thing. But when you consider 2 pages, that will clarify the intent. But you can take the trouble to consider page 26 of the written application.
1 second. Wow, 1 second. You are appearing for?
46.
Who are they?
National Insurance Company.
Page
26, Lord, can you take the trouble?
Page 26
of the return. The appointment letter issued by National Insurance Company.
Redeployment.
Redeployment.
Redeployment. 1 second. 1 second. Yes.
The date is vital. Not to page number 18th August 2020. 2011. Right hand side top.
Which is not 28th June.
1990.
Not 28th June 1995.
Dr. Can you take that out page 34?
Achha, 1 second. Let me read this language. Join the service of the corporation or a company as the case may be before 28th June.
1995. Now, Dr. Can you take that out? Join the service of the corporation or the of a company.
Kotha, where?
34.
Yes. Next clause.
Clause 10. I am on clause 10.
Right. Read on.
Also, so far as 11 is concerned, there. Join the service of the corporation or of a company, as the case may be, before the 28th June 1995 and continue.
This joining means the original joining or deployment, redeployment.
So far as I am concerned, I am National Insurance Company Limited. I am covered under this because this is GIC Pension Scheme 1995 amendment. So it applies to me. My reference company and my reference was never an employee
of national
company or corporation. GIC was a corporation. General Insurance Corporation Thereafter, four national
Formed.
insurance companies have been framed. So government took the decision. The tariff committee was there. It has been dissolved, and the employees will be redeployed in different
Insurance company.
As per the government decision, he has been redeployed in our company in the year 2011. Now the 2019 government has given a chance to the employees to again apply for pensionary benefit, which they could not avail earlier. One condition was there, subject to they were in employment on 28th June 1995. Admittedly, my reference client was never there. And the redeployment letter, if you should kindly consider, it speaks about he is covered under pension, he is covered under provident fund, and as per the provident fund, the pension scheme is there. Whatever is there, he is there. Now he applied under a misconception that he will be
Converted.
He will be converted, and the first initial appointment, the date he has given in his application, wrongly it was there. Then we said, and I think.
So according to you, this 28th June 1995
is the cutoff.
Right, but the same should be his appointment with your national insurance. That is your case.
So yes, that is the interpretation of this.
So that we have to read it. We'll have to read it. So according to you, who have joined national insurance as on or before 28th June 1995, they will get it.
And that will be more clarified or to consider.
Acha. So according to you, that option was given for those employees to re-choose who have joined before 28th June 1995. But they did not choose. Now they can get another opportunity. Sit down.
And also can you consider clause 11? That gives a better clarification. Join the service, corporation or a company, as the case may be before such.
Because tariff committee was neither a corporation nor a company. That's
Well, here.
And also, wrongly we have, my understanding has correctly said, he was given benefit wrong, under wrong assumption. When it has been cross-checked, the direction has been given to the bank to stop.
But refund or withdrawal or realization?
I don't think 1 or 2 months were there.
Oh. So what has been paid has been paid.
refund হয়েছে আপনার?
টাকাটা হ্যাঁ টাকাটা রিফান্ড
আপনারা কি রিফান্ড
হ্যাঁ কন্ট্রিবিউটরটা আমাকে রিফান্ড করেছে
করে দিয়েছে না যেটা পেনশন পেয়েছিলেন
হ্যাঁ
ব্যাংক থেকে যেটা
পেনশন তো চালু হয়নি
পেনশন
তো চালুই হয়নি তার আগে
whatever money he has deposited, that has been returned to them.
That is for the contributory portion, which I deposited.
Yes.
Along with check. My lord, here, my lord, I shall draw my lord's attention that joined in the service of the corporation or a company as the case may be. As the case may. Here.
As the case may be.
Maybe.
Which
here,
means?
I was employee of the Tariff Advisory Committee.
As the case may be means?
Here, my lord, on redeployment, I joined present company from the TSC, Tariff Advisory Committee.
Kindly come to this sentence, sir. Joined the service of the corporation or a company. As the case may be before. So you show me that before 28th June 1995.
Yes.
You were an employee of either a corporation or a company. Show me.
I was my lord, employee of the Tariff Advisory Committee
So it was not a company, neither a
Not a
corporation.
company or not a corporation.
So how you will get, how it can come within this expression?
Because, my lord, this scheme applies to the employees of the erstwhile Tariff Advisory Committee. I read the letter my lord, issued by the government of India. The scheme also, my lord, applies in our, my lord, erstwhile Tariff Advisory Committee, erstwhile, my lord, employer. I enjoy the scheme.
Show me from your writ petition.
Yes. Page, my lord. Page 28.
Yes.
The proposal has been approved by the board of TSC.
Sir, read on. Read.
Scheme. It is written. It is
Pension scheme.
From the Undersecretary to the Government of India, my lord, to the Secretary Tariff Advisory Committee. My lord, here pension scheme for TSC employees. The undersigned is directed to refer to your reference number such and such on the above cited subject and to intimate that the central government have no objection to your proposal for adoption of the General Insurance Employees Pension Scheme 1995 for the employees of the Tariff Advisory Committee subject to the conditions that there is no financial implication for the government. Secondly, the proposal has approval of the GIC who will have to meet the financial liability, if any. And thirdly, my lord, the proposal has been approved by the board of TSC. It is
These are
adopted.
the proposals. You show me it was effected. Show me that effect. Proposal, yes. Why not?
পেনশন স্কিমটা যে এত হয়েছিল তার
প্রথমটা আগে পেয়ে যেতে
Government has cleared that they are not interested. The finance department.
My lord, here, my lord, proposal, but approval. Your lordship asking me to produce the approval.
I want to see that
the scheme was
Implemented.
implementation.
Yeah.
Lord,
You cannot show because I tell you, it cannot be. Read this. The answer is here. Huh? The answer is here. Kindly read the letter. Your answer will be here.
undersigned is directed to refer to your reference number such and such on the above cited subject and to intimate that the central government have no objection.
So wait. Central government has no objection. To what? Read.
Objection to your proposal.
Proposal
For adoption of general scheme for the employees of the TSC, subject to the conditions that there is no financial implication to the central government. And secondly, when a proposal has approval of the GIC.
So show us these things.
My lord,
Show.
may I say one thing before your lordship? It was introduced. So far my instruction is introduced.
Sir, hearing matter
Yes.
on affidavit,
Yes, yes.
which is not on record, don't submit. It is on affidavit. You have got your chance in the petition, you have got your chance in affidavit in reply. So no further. Do it and complete it today itself.
paragraph. Well, other matter, three matter is there. Other matter, my lord, I got a letter issued by the authority, New India Assurance Company. Herein, they told that indicated in case you had opted for pension while you were in service with Tariff Advisory Committee under the General Insurance Pension Scheme 1995, you would continue to govern by the same scheme subject to production of the enrollment records from the date of absorption and company.
So in case, show that you cannot show because these four things are required subject to these things. They have applied, they approved on principle. Show me from your petition that it is implemented. The short question today, whether you will be covered under page 34 or not.
Yes.
Page 34 or not.
No.
If you are not covered under page 34, matter ends.
Yes.
So you show me that you are covered under page 34. Matter ends.
Page 34, my lord, the cut-off date is 28th day of June to the 1995.
For whom?
That is the corporation and company as the case may be.
So corporation or company. So you show me that before that you were either in the corporation or in the company.
Before that, the I asked my lord.
Which means either you were in GIC or you were in those four companies which are the siblings of GIC.
Admittedly, I was employee of my lord Tariff Advisory Committee, where
So it was neither a corporation nor a company.
wherein scheme introduced.
It did not cover your Tariff Advisory Committee. This page 34 does not cover.
Language is joined in the service of the company or a company.
Corporation or a company. You show me you were joined either in GIC or in any of the four insurance companies.
My instruction is.
Sir, instruction I will.
My lord. By document I shall produce, my lord.
You shall.
But if your lordship.
Hearing matter, no question of shall.
To file a supplementary affidavit.
No. Today itself, whatever. Today itself.
But
then if you say that, then your redeployment will go. Choose. Then your redeployment will go.
Redeployment, my past service was accepted.
Sir, if you say that you are an employee either of the corporation or of the company on or before 28th June 1995,
95.
right?
28th June 1995, the cut-off date.
Then your redeployment in national insurance
Insurance.
on 18th August 2011 will be nullified. Choose your way. Then automatically, if you are already an employee of the corporation or a company, you cannot be a further employee of national insurance company by virtue of redeployment.
But the Tariff Advisory Committee is my lord, statutory body under the Insurance Act.
Yes. So what?
Under the Insurance Act.
So what? Who denies? Then choose your stand. Then your redeployment will go.
But redeployment, my past service.
You are an employee of national insurance,
At present,
right? By virtue of what?
by virtue of my redeployment,
Correct. So before redeployment, you were with whom?
Tariff Advisory Committee, but my past service accepted.
Sir, that is all right. But your tariff advisory committee was not covered under the scheme. Your first service might have been accepted for your service benefit. Yes, and continuation. Continuation. Pension, gratuity, that's for provident fund, that's for the continuation.
But the employees of the Tariff Advisory Committee, my lord, allowed pension under the same scheme.
Show me.
That is the my humble submission before your lordship. If your lordship allow me to file a supplementary affidavit.
Then, sir, why you have proceeded today?
My lord,
why? If you are not ready, sir.
No,
hearing matter.
Your lordship, my lord.
Petition, opposition, reply.
Very short question. Very short question. Whether this scheme was allowed to enjoy by the employees of the erstwhile Tariff Advisory Committee.
Correct.
This is, my lord, allowed.
How it will? The language is corporation or a company. Tariff Advisory Committee is not a corporation nor a company.
That is right, my lord. From the language of the my
Tell me, sir. You tell me, sir, reasonably.
My humble prayer before your lordship. If your lordship allow me only 7 days time, my lord.
Sir,
in the meantime,
nothing in this year. Hearing matters, everybody is mentioning. When the matter is reached, if you are not ready, then what to do? I will give you opportunity.
Take the trouble to consider affidavit in opposition, page 15 and 16. Especially page 16. Government of India, Ministry of Finance, has already said they are not eligible. But if I take the trouble, page 15. And this aspect, my representative client has not denied that this is wrong or this is under check. Page 15, Dr. Can you take the
Where?
This is the letter of the Government of India, Minister of Finance. Letter dated 30th June 2023. Has the Lordship got it?
Yes.
Dr. Can you take the trouble? Next page. I will not trouble your Lordship more than one or two clauses. The one more option for
1 second, 1 second. Yes, sir. Come, your answer is there. Kindly come to page 15 of opposition.
Opposition.
And they have never said that they have again challenged this.
Ask your junior to find out the paragraph in affidavit in reply dealing with annexure R1. Reply.
Page 15.
Yes. Annexure R1. Read paragraph 2 loudly.
The said request is based on the following grounds. the then Department of Economics Affairs, Insurance Division, via letter dated such and such, allow the proposal of TSC to adopt the General Insurance Employee Pension Scheme 1995. Allowed for the employees of TSC, subject to the condition that there is no financial, that is like page earlier 30.
Wait, you read on.
Proposal has approval of the GIC, who will have to meet the financial liability, if any, and third, my lord, the proposal has been approved by the board of TSC. Next, TSC employees were extended similar pay scales and terms and condition of those applicable to employees of GIC and GIPSA members companies, and amended from time to time, including SBRS in line with SBRS 2004.
Next.
The matter has been examined in this department and the following has been observed in this connection. Next page.
Read on.
The one more option for pension is open via notification number such and such was applicable to the employee.
Which is this notification? Read the date.
23rd April 2019.
So which is page 34? Now read on.
Was applicable to the employees of the PSGIC who were earlier eligible to the General Insurance Employee Pension Scheme 1995 by virtue of their being in service prior to 28 June 1995. The absorbed employees of erstwhile TSC were not in services of PSGIC, that is admitted. I was never.
So read on.
To 28 June 1995.
So,
but here the government, my lord, did not, my lord, mention anything that the scheme was not applied in the erstwhile.
What more it will say? This reading of the scheme says.
So clause 4 of that.
Here, my lord, here says that
categorically says it is not applicable to TSC.
Kindly come to last paragraph.
Last paragraph.
The accrued individual balances.
No, last paragraph.
4. Serial number 4.
Yes.
In view of above, the proposal for allowing for one more option.
Which is that scheme?
Amended scheme.
Yes.
Pension to the erstwhile TSC employees is not exceeded to.
Matter ends.
But, my lord, before this circular or order, they have rejected. The national
Which circular?
This letter. This letter was issued when, my lord? June 23.
30th June, yes.
Well, before that, they rejected.
What rejected?
My pension.
Kindly come to the scheme. Scheme.
Came to
Page 34.
Yes, my lord.
2019.
19.
Yes.
No, my lord. I applied for.
Sir, application, no application. First you show your right.
My right.
Yes.
My right.
You have no right under this amendment scheme.
My right is, it is presumed when they are.
Sir, on presumption, right cannot be conferred. You show me that your right is there. Page 34, you have no right. Page 15 of affidavit in opposition, you have no right.
But I have challenged it. This letter issued by the Department of Ministry of Finance.
Where is your challenge in the writ petition?
Writ petition not. It was my lord circulated.
The policy decision you will challenge.
Because
in a reply, yes.
Page 9, paragraph 5.
I have also, my lord, in my reply stated the said, my lord, order passed by the Ministry of Finance, and also I have prepared a supplementary affidavit challenging this document.
Very well. So in view of the scheme, you are not entitled. Matter ends.
But
in view of the scheme, you are not entitled. Matter ends.
But my humble submission before your lordship, since the original scheme adopted by the TAC, my erstwhile company, my lord, and I was enjoyed the said scheme, and well, after amendment, one chance was
You
given.
just erase this the cutoff date and these two expression corporation company, it will be applicable. Erase it.
I cannot erase it, but my lord, understanding that the corporation or company, when the TAC, my lord, when the government of India, my lord, decided to, my lord, keep the employees of the TAC in the same field, it is also, my lord, under the Insurance Act.
Sir, it is a policy decision. Government thought it fit not to give you that benefit. It did not give benefit. Matter ends.
Well, one thing, if there is no redeployment, then I am a employee of the, my lord, TAC, and I am also entitled to file one more option since the scheme adopted by the TAC, and I am entitled to get the pension.
Sir, question is whether you are covered under this scheme or not. I will simply say you are not covered under page 34. Matter ends. I will not say a single line more with regard to your entitlement or eligibility or your right.
But I was originally governed under the said scheme.
Maybe, but this date and the expression corporation and company, what do you do? And then read with page 15 of the opposition.
Page 15 of the opposition, subsequently this letter was, my lord, annexed in the first time in writ petition. Before that, they have rejected my claim, my lord, without referring this letter. I have challenged the decision of the national company, insurance company.
You are claiming the benefit under page 34.
34.
Now page 34 ex facie shows you are not covered. Matter ends. What to do?
Your lordship, my lord, that my corporation or company, my lord.
Corporation, company, and the cut-off date.
Cut-off date, if it cut-off date, my lord, I was there. I was under the
TSC,
company.
TSC. No, it was not a company.
1990.
It was not a company. TSC was not a company.
No, this is a statutory body.
It is a board at best.
Statutory body under the Insurance Act.
Right. But it's neither a company nor a corporation. Ashun. This is a hearing matter on affidavits. সবার নাম ফাম লেখা আছে তো পোস্টার এটা জাজমেন্ট করে দেবেন
সেটা বলেছে এখন পরে বলবে সেম জিনিসটা দেয়নি অমিত সিং কেসে 21 দেখুন পরে দিয়েছে পরে দেয়নি আছে আগে সত্য
Since when you were in employment of TSC?
1990. I have annexed the appointment letter, that is page, my lord, 18. Appointment of
the petitioner on October 30, 1990 was received and has received an appointment, has received an employment of the Tariff Advisory Committee. The then existing Tariff Advisory Committee, TCAP, ACAP, CCAP, bracketed for short TSC. The appointment letter is Annexure P2 at page 18 to the writ petition. Subsequently, by virtue of the policy decision taken by the Union of India, the said TAC was made defunct and or non-existence, and the employees were absorbed by spreading them over into the four insurance companies, four nationalized insurance companies.
Plus 4, page 21.
New India Assurance Company.
Yes, sir.
In India.
Yes, sir. Yes, sir. Yes, sir. কি বললাম পূর্ণ? Policy decision dated April 25, 2011. Taken by the Insurance Regulatory and Development Authority, Union of India, Insurance Regulatory and Development Authority, ICAP, RCAP, ACAP, DCAP, ACAP. Employees were redeployed and spread over in the four nationalized insurance companies mentioned therein. Annexure P3 at page 21 to the writ petition. Accordingly, the redeployment letter dated August 18, 2011, Annexure P7 at page 26 to the writ petition, was issued in favor of the petitioner, and since then the petitioner has become an employee of National Insurance Company. Bracketed for short NIC, National Insurance Company Limited. But she retired or what?
At present retired.
In due course, the petitioner has retired. Paragraph.
31st January, superannuated from the service.
The Ministry of Finance, Union of India has published a notification originally dated, published an amendment notification. Now, Kato has published a pension scheme.
Amended pieces.
Under the name and style, General GCAP, bold Insurance ICAP, bracket employees, pore apostrophe, bracket, first bracket close, pension PCAP scheme SCAP, 1995, bracket the said 1995 scheme, said 1995 pension scheme. কি বললাম? has adopted and published. Post. The same was amended subsequently. Post. By virtue of an amendment notification dated April 23, 2019, Annexure P9 at page 29, bracket A, specifically at page 34, bracket close to the writ petition. Post. Paragraph. The said amendment notification has introduced inter alia clause 10 after subparagraph clause now the subparagraph korun subparagraph English 10 after subparagraph English 9, which is quoted below. এই একদম না 3 থেকে আমি দাগ দিয়ে দিলাম কোট করে দিই from page 34 quote 1. Post. Paragraph. By virtue of the introduction of the said amendment, the employees who joined the service of the corporation or a company, comma, as the case may be, comma, before bold, June 28, 1995, and continued to be in service as such on the date of publication of the said amendment scheme 2019, were provided with certain beneficial facilities, which inter alia includes the change of their option from
my lord, contributory provident fund
scheme bracket CPF
to pensionary
to
pensionary scheme.
Pensionary scheme. Post. Paragraph. এই ধরনের মামলাগুলো খুব বেশি তো সাবমিশন বা এইসব রেকর্ড করা যাবে না, যেহেতু করে টেনে প্যারাগ্রাফ করে দিয়ে শেষ করে দেবে। ঠিক আছে, কি বললাম? আর যেগুলো করা যাবে সেগুলো করে দেবে, তারপর আমি কারেকশনের সময় দেখাবো। Full stop. The petitioner claiming the same benefit under the said amendment scheme of 2019 claims the option for conversion. And has filed the instant writ petition with the following prayers. Prayers A to F from page 14 of the writ petition, quote 2. Mr.
Shamul Kumar Das.
Huh?
Shamul
Kumar Das, learned counsel appearing for the petitioner. Submission ওপরটা ফ্যাক্স হয়ে গেল বা সাবমিশন এখানে ভাগ করে দিন Learned counsel appearing for the petitioner submits that the original 1995 pension scheme was applicable for the petitioner when the petitioner was in the employment of the said TAC, TAC. She has received all the benefits thereunder. Accordingly, the said amendment of 2019 is merely a consequential event and the petitioner is eligible to receive the benefit of conversion thereunder post paragraph. Learned counsel for the petitioner then refers to a communication dated March 26, 1996, annexure P8 at page 28 to the writ petition and submits that the Undersecretary of the Government of India informed the TAC, TAC that the government had on principle agreed that the central government that the central government would have no objection to the proposal for adoption of the central government insurance, the said pension 1995 pension scheme for the employees of TAC. subject to certain conditions as mentioned in the said communication. He submits that the said communication shows on principle the union government has accepted the operation of the said 1995 pension scheme on the employees of TAC. Therefore, the consequential amendment of 2019 should also apply. Full stop. Yes, sir. What else? Tell me. No, what more submissions if you have anything?
Since my more submission means since I was in the service in prior to 28 June 1995 and same scheme was
Learned counsel for the petitioner submits that since the petitioner was in employment of TAC much prior to June 28, 1995, the petitioner is entitled to receive the benefit under the said 2019 amendment.
and also the present employer accepted my initial service as a continuity of the service.
Full stop. Petitioner, the employment of petitioner was a continuing service even after she
as per clause 4 of the redeployment letter.
Even after she was redeployed with the National Insurance Company. These are your submissions? These are your submissions?
This is so far my lord service. And next, my lord, since my lord scheme, the general insurance scheme 1995 covered the erstwhile employer, and it is presumed that my service should be reckoned as a, my lord, employer of present employer on redeployment.
You are an employee of present employer.
Yes.
On redeployment. Who denies?
But on redeployment, I am entitled to get the benefit of the scheme.
That I have said. Full stop. In the light of the above, learned counsel submits that the writ petition should be allowed. Paragraph. Par contra, Mr. Ronojoy De, learned counsel senior advocate appearing for the National Insurance Company at the threshold refers to the said 2019 amendment scheme and submits that the language of the scheme is very specific, that the amendment to the effect that the amendment shall be applicable for those who join the service of the corporation. Yes, Mr. De, please. Of the corporation, namely the General Insurance Company. I'm coming. First the corporation. Ki bollam?
And the service of the corporation,
Namely the General Insurance Corporation and the 4 other nationalized insurance companies. comma, as the case may be, before June 28, 1995. Admittedly, the petitioner prior to June 28, 1995 was neither an employee of the General Insurance Corporation, neither of any of the 4 nationalized insurance companies. The petitioner was redeployed with the National Insurance Company on August 18, 2011, much after the said cut-off date of June 28, 1995. Poster. Thus, the scheme shall not apply in case of the petitioner. Poster. Paragraph. He then refers to a document being dated June 30, 2023, annexure R1 at page 15 to the affidavit in opposition. Filed on behalf of National Insurance Company, and submits that the Union Government, Ministry of Finance had taken a very specific stand that they said one more option for pension as opened by the said amendment notification dated April 23, 2019 was not applicable for the erstwhile PAC employees. These are your submissions. Any further? In the light of the paragraph, in the light of the above, Learned Senior Counsel for the National Insurance Company submits that the petitioner is not entitled to get any benefit under the said 2019 amendment scheme, and the writ petition is devoid of any merit and should be dismissed. Paragraph. Decision. After considering the rival submissions of the parties and on perusal of the materials on record, it appears to this court that the core and solitary question to decide the instant writ petition is whether the said amendment scheme of 2019 introduced and published in the Gazette notification dated by way of a Gazette notification dated April 23, 2019 at page 34 to the writ petition would cover the petitioner or not. Paragraph. The said scheme has a statutory flavor. Poster. The law is well settled that to interpret such a statutory scheme or to scrutinize the same as to its applicability, the correct approach should be read the same as a whole. The correct and proper approach, in law, should be to read the same as a whole. Poster. Paragraph. On a harmonious construction and on a plain reading of the scheme, it is clear that the amendment scheme of 2019 mentions that the same shall apply for those who joined the service of the corporation or a company, comma, as the case may be, comma, before June 28, 1995, and continued to be in service of the corporation or a company on the date of publication of the said amendment scheme. Paragraph. The admitted fact is the petitioner was originally an employee of TAC since 1990. And thereafter, she was redeployed with the National Insurance Company on and from August 18, 2011 at page 26 to the writ petition, which is much subsequent to the effective date of the said amendment scheme being June 28, 1995. Paragraph. On a reading of the said scheme and in the facts and on the basis of the said admitted facts, there cannot be any second opinion that as the petitioner was not in service either of the corporation or of any of the four nationalized insurance companies before June 28, 1995, the petitioner cannot be covered within the scope and ambit of the said amendment, the 2019 amendment scheme, and no benefit can be claimed by her thereunder. Post. Paragraph. in as much as the said document being June 30, 2023, at page 15 to the affidavit in opposition, comma, as referred to above, also clearly shows that the Finance Department of the Government of India did not accede to the proposal to include the TAC employees within the said amendment notification. Though the petitioner in its affidavit in reply, in paragraph 5 to its affidavit in reply, has challenged the same. But this being a policy decision, no, reply paragraph 5, he has challenged. Paragraph 5 in his reply, affidavit in reply. Opposition is 9, reply is 5. Thank you. Has disputed the same and contended that the said document was illegally issued by the government, by the Union of India, and was against the decision in terms of the redeployment order dated April 25, 2011. But the same being a policy decision of the government, unless ex facie shown to have been perverse or illegal, no such contention is sustainable in law. Paragraph. In view of the foregoing reasons and discussions, this court is of the considered view that the petitioner is not eligible to receive any benefit under the said 2019 amendment scheme in any manner. Paragraph. The writ petition is devoid of any merit. Full stop. Paragraph. Accordingly, the writ petition, bold, WPA 6611 of 2025 stands dismissed, comma, without any order as to costs. Sorry.
It's my duty to assist before
No,
your lordship.
Absolutely.
Every case I may not be, but
Absolutely, absolutely. Absolutely. And it is also possible that I might have some wrong understanding. It is also
No,
possible.
my lord's my lord view, that is the regarding the my lord,
Absolutely, sir. It is-
regarding the my lord.
But the way I received the assistance from the bar and all of you, and in this matter, you have both of you have assisted. It's amazing, fantastic, fantastic. Unless this assistance is there,
Actually,
the court cannot
actually
perform.
one line, my lord, that is defeated us, my lord. Only one line.
Court cannot, unless this assistance is there, court cannot perform.
The next matter is the same. Only name is changed.
Who is for the petitioner?
Well, as a printed.
All pages are also same.
Possibly no. So may I submit to your lordship kind approval? From next week, your lordship will kind enough to take the give us a chance so that the matters can be disposed of, because 3 matters are in the same line.
The
All
new
ma-
new Indian matters is different, my lord.
Actually, new Indian-
Next matter is similar. Next matter, I admit it. Amit to একই।
সার্কুলারটা দেয়নি
Amit to একই রকম।
টাকাটা পেমেন্টটা ঢুকিয়ে এটা ঢুকিয়ে দেখে একদম 60 মাস
Then we
পর
can indicate where
টাকাটা দেয় না?
না টাকা দিয়ে দিয়েছে উনি ইনস্টল করাবে
ঠিক আছে, আসুন।
Next matter, I was enjoying pension.
পেনশন they are paid
Yeah, sir. Huh?
paid can be
No, I will not observe anything on that. I will simply
Regarding the my lord, applicability of the amendment scheme, your lordship.
if you have received benefit, you have received benefit.
and we have not withdrawn.
No, that is not even under challenge. And I will not make any comment on that. If any
Your lordship
benefit
held
has
that
been,
whether this scheme will my lord apply in my.
I hold that.
Yes.
The scheme is not applicable.
Yes.
Whether you have received any benefit, you
Yes,
have
beyond
received.
that, no my lord, the issue is. my
If
lord,
you have
your
received benefit, you have received benefit. No issues. ঠিক আছে, এটা একটা অর্ডার করে দিতে হবে তাহলে। আসুন, লিখুন। Mr. Shamul Kumar Das, Learned Counsel, appears for the petitioner. পরেরটায় Mr. Ronojoy De, Learned Senior Counsel, appears for the respondent. Which company?
same company,
National Insurance Company. Madam Shipra Chandra for.
My learned senior Songjukta Bhattacharya.
Both of you are there. In the last matter also you were there.
All 3 matters, my
So give the name.
I have given.
ওই দিদিদের নাম জানা যায়। আচ্ছা, MS সংযুক্তা Bhattacharya, Learned Advocate, with MS Shipra Chandra, Learned Advocate, appears for Union of India. Full stop. The Learned Counsel for the parties submit that this writ petition involves an identical issue with that of the immediate previous writ petition, being WPA
WPA 6611
WPA 6611 of
2025.
2025. Poster. Accordingly, this writ petition shall appear under the heading forwarders on. আজকে কত দিবি? সময় দিই, এটা করবো, এখন তো ছুটি পড়ে যাবে। August 21.
21.
Because 4 days are holiday.
Yes. 21.
August 21.
I'm under the dispose of
August 23.
No, forwarders is in the morning. Whenever the list will follow.
August 21, well, I maybe Jalpaiguri, my junior will assist you.
No. Why? How does it matter? One day, this and here and there. Tell me when. You tell me when.
23rd, 24th.
When you will be here.
After 22nd.
Absolutely, no issues. Why?
Can it be on 26th or
Next week, two matter fixed on the Jalpaiguri.
Absolutely, you are welcome. You tell me.
No, no. After 27,
On,
any date.
on August 26,
Yes, sir.
2025. Because thereafter, 2 days and then I will be in Jalpaiguri.
And just one respect to some. Observe that it has got a statutory flavor. Only one sentence can be written as it is framed under section 17 capital A of the nationalization.
How does it matter if it has a statutory flavor? I said it is a statutory flavor. Thank you. Thank you.